Knock, knock. All right. Morning, everybody. We're starting the subcommittee for Senate Bill 277 by Senator Hennessy. And I have a few comments. And we distributed a few pieces of paper. Unfortunately, we didn't get them. I didn't get them till last night. I wish we were sent them earlier so everybody could have a chance to look at them. One of them is the OPLC draft legislation from the director, and another one is from Bob Clegg's organization right there. Anyway, so the original bill is a good bill. It allows us to hire more people we desperately need. The way it goes around it, it's extending the state of emergency, not state of emergency, but the emergency authorization by another 2 years. And the committee, I think the members of the committee felt that the emergency has been over for a little while, so why extend it another 2 years to have a 4-year emergency? So we got to fix it in a different way. And one of my questions, maybe the director can answer that, since all those licenses expired 4 months ago, like, how are those people operating? If you would like, I'm sure we'll have more questions. And I'm good with them working. I'm just curious as to the process.
Thank you, Representative. For the record, Lindsay Courtney, Executive Director, OPLC. What we did in January in order to avoid the expiration of the emergency licenses, as you may recall, January looks different than April does in 2022, is we converted via emergency rule all of those licenses to temporary licenses under existing statutory authority, which is in 310A. So those licenses actually don't expire until May 31st. And it was really intended to give the legislature an opportunity to determine what, if anything, to do with these emergency licenses.
Okay, thank you. Anybody has any questions, please, Representative Gawley.
Thank you, Mr. Chair. Quick question. Obviously, if this is amended, it's got to go back to the Senate for approval and still got to go to the governor. And I'm not sure whether or not this would be done by May 31st. What would happen at that point?
If it was not done by May 31st, all of those licenses would expire. We do not have statutory authority to further extend those licenses.
Please.
And Mr. Chair, I don't believe we can go back retroactively to reinstate those licenses either statutorily. So that puts us in a quandary as to whether or not the governor knows this is in the pipeline and we can really push this forward and fast track it to get it done before May 31st. I'm hoping that could be done if we do something.
Thank you. Yes, please.
And then there was one other question that I had as to why we continue the mail order pharmacy license at no cost in this legislation. I have an issue with that.
So, right. There were really only 2 or 3 instances in which we allowed the pharmacies to operate a mail order pharmacy. I don't take a position. I personally think that one of the reasons why we recommended converting these licenses to permanent licenses was the loss of revenue to the state. Regarding the mail order pharmacies, the loss of revenue has not been significant because it's only been a couple of instances. Typically, the mail order pharmacies, though, the fee is $2,000, which is significant. The 20,000 or so, 22,000 people who did obtain an emergency license did so without cost to the state or without cost to them. So, I certainly would be supportive of adding in that fee.
So,
Yes, please.
Mr. Chair, if I may, I would like to see the amendment removing the line that says at no cost, and if they're going to be renewed, that they pay the license fee.
Please, which line? Oh,
That is line 14.
okay, thank you.
Or I guess my question is, do we even need that section in if we're going to charge a license fee? Can we just strike out that section with the emergency order?
Yeah, I think you could strike out that section. We are currently charging a fee for new temporary licenses that we're issuing for 120 days. That fee is $25.
So, Mr. Chair, if
Yes,
it's
please.
the will of the committee, I would move that we strike out that whole section from line 12 to 15.
Go ahead. So, okay, thank you. So yeah, you're good. Okay. So the draft amendment by the director right here, we all got it. That's the shorter page. That only modifies section 1. So I don't know what happens to section 3. If the director can come come back. Yes. Because it's not clear to me why section 3 is not converted just the same as section 1.
I think no, actually, there are many license types that are multi-state licenses. Yep. No, for nursing, for example, we issue compact licenses, which are considered multi-state. No, I can appreciate that. I think, Representative, you probably would need to change section 3 as well, except that, well, I think section 3 deals with the continuing issuing of licenses. So this bill really is intended to do two things. One is to convert the existing emergency license, or to extend the expiration date of the existing emergency licenses to 2024, and then to continue to authorize OPLC to issue emergency licenses. I will say that we have observed a significant increase in the amount of correspondence related to the student nursing emergency licenses, which would fall under section 3 when it states that the Office of Professional Licensure and Certification shall continue to offer and issue emergency licenses for healthcare workers, and those licenses would expire January 31st of 2024. So I don't think that there would be a need to convert those licenses, because section 3 is talking about licenses issued in the future, whereas section 1 is talking about licenses previously issued.
Thank you. Please, Representative Gawley.
I still would like to see 2024 change to 2023. I don't think we need to go out to 2024 giving emergency licenses at this point. If there is a need, we can come back next year and extend it out. I guess my question to the director is, if we keep section 3 in, does that fiscal note still stand? That's the issue I have, the $680,000. I think giving folks until January 31st, 2023 is enough time.
Thank you.
I do think that the fiscal note would change. I don't know off the top of my head. I wouldn't be able to do that calculation right now, but I think certainly there would be a change to the fiscal note if you were to change that date. There's a cost to the extent that we're issuing licenses without a fee. So certainly you could make that modification that we issue licenses with a fee. Additionally, if we were to convert the licenses and they would be required to renew, they would have to meet all requirements, which would include paying the fee on renewal. But if you were to just extend out the licenses an additional 2 years without receiving fees for those licenses, then yes, that could potentially be a loss because those people would not have sought potentially permanent licensure and actually paid the fee. But the fiscal impact really isn't determinable because we don't know how many of those would decline not to seek permanent licensure as a result of having the emergency license. It's just hard to tell.
Oh, a
I'd
microphone.
prefer to see it go to 2023.
I'm good. Thank you. Please, microphone. Yeah. Thank you.
I would set the date to when can the next legislative session realistically do it, so that we're not doing, oh, this thing's already expired, what are we doing? And, wouldn't it be more into some halfway through 2024 or something before something could actually be, in halfway through 2023 rather than January 31st? I mean, when will they
hear
be
you.
meeting and
Summer.
the Senate, the House, the governor signing it?
Summertime.
Yeah, isn't January kind of unrealistic?
If I
Representative
may
Gully.
respond, I think there comes a point where we have to decide whether we're truly still in a state of emergency for this, or we need to look at these folks and say, listen, you either need to get a New Hampshire license and determine whether or not you're staying here for that reason or not. And that's, we need to set a deadline on that, not just using an emergency as
I
an
see your
excuse.
point, but it just, in terms, we're kind of scrambling with this because the date was not realistic. And that seems like January 31st is also not realistic, right? They're not even swearing people in for the next session till then.
So I have a question then. Why don't we convert Section 3 just the same to the regular licenses? What's the drawback? Maybe. I guess that's-
So Section 3 would allow us to continue to issue emergency licenses based on the limited criteria for out-of-state licensees that they have a license in good standing. It would also allow us to continue to issue licenses to student nurses and medical fellows. With respect to the first category, there was a bill, Senate Bill 330, that would have allowed the office to issue licenses, permanent licenses based on that criteria. But obviously, there was significant concern from certain stakeholder groups. So that bill was amended to essentially study the issue. And I think that part of that study, legislative study committee, could be looking at what do we do with these emergency licenses? Because certainly portability is an issue in the state. The way we fixed it temporarily during the pandemic was to allow us to issue these licenses. But the question is, how do we pull that back? Or should we?
Thank you. And if we convert most of them to permanent licenses, when is the next renewal? Is it yearly? And they have to qualify?
It depends on the
License.
licensed profession. So they all renew. Most of them renew on a biennial basis. Nurses, for example, renew the month of their birthday. Physicians, though, only renew in June. June 30th is the common renewal date. So if you were to convert them, I think that you would have to potentially change the effective date to make it
Just like the amendment recommends.
to make that section. The concern would be, right, if you were to convert them and then if the bill were in effect June 1st and then all of a sudden 15,000 physicians have to renew in a 15-day period, that would be problematic. We wouldn't be providing the required statutory notice of 60 days. So I might say, rather than one thing you could do on the proposed amendment, because of course when we drafted this, we were anticipating maybe this would be an earlier bill. You could say convert it to a permanent license, or you could say for purposes of renewal. Oh, okay. This is fine. The way it's written, for purposes of renewal, the date of conversion shall be deemed the date of original issuance. So they actually wouldn't have to renew right away. I apologize, Representative. I'm
Okay.
talking this through.
Thank you. Okay. Would Senator Clegg want to testify? And do you have any input on the summer camps? Because we got the what's if you I mean
Thank you, Mr. Chairman. The camps have a problem with, and it's the same problem I think that everybody does that has a provision that says you have to have a registered nurse. So one, we're having a hard time finding them. And two, the ones that we have come here and they've been working under temporary licenses. So we really need to have this fixed before June, because our camping season and our youth camps open in June. Whatever you do, if it helps us, we're going to work with the Senate to see if we can't get them to rush it through to the governor's desk to get it done. To us, it's a matter of life or death. If this doesn't go through, we can't open without registered nurses.
so what's the timeline in your mind looks like? Can we get it done by what is it, May? Is it May? Well, we have right, June 1st. If we amend it here,
We don't have a choice. I don't know when your next session is. If you can get it on your calendar right away,
Well,
then we can get the Senate to be nice.
If all their regular stuff expires June 30th, as she just said, just make it June 30th.
this is May 31st, I believe, the temporary extension. So June 1st.
The sooner you get it on your calendar, Mr. Chair, the
bill, no way we can get it on the calendar for this Thursday. The next session is going to be the 5th or 4th, depending on how many bills.
then as soon as you get it passed, we'll go beg in the Senate to get them to push it, and we'll speak to the governor's office. Obviously, it's very important to everybody. The nursing homes are having the same issue, so anything we can do to ease it up just for this year. I'm sure it's going to come back next year. Some kind of resolution, permanent resolution.
Looking at the overall requirements for licensing and the places we offer licensed people that we may not. I mean, why do you need a registered nurse at a youth camp other than one for people with special needs?
I don't disagree. And I think that if we felt that there was a need, it'd be nice to be able to hire some EMTs that maybe have, I mean, those are perfect type of people to bring in, so.
Yeah, I mean, you need somebody who can deal with accidents and falls and know when to send the kids to the hospital.
Yeah.
Is that part of the issue that's being addressed in that study committee that we were just heard about?
We hope so.
3:30?
We have a hearing on an amendment to that bill this afternoon, and if we like it, we can incorporate other changes.
Thank you. And there was a note from Madam Chair with psychology. It was something about psychology.
Oh, yes,
Is it something
we've
special?
already covered with that. The fact that psychology has some weird requirements for a permanent license is something we're covering in the study of mental health licenses we just approved yesterday. So
Okay. So we don't
that's
care.
why there's so many temporary and emergency licenses in psychology, is because the requirements for a permanent license are felt by many people to be excessive.
Okay, thank you. So my inclination is to strike all the dates out and either convert everybody so that they get to go through the renewal process whenever is applicable, so we don't have to come back to do this again. Representative
Is
Bailey.
one of the possibilities to just leave it as it is, expiring January 1st, 2024 or 23rd? 31st, 2024, just pass it as it is. And then we don't have to go to the Senate. We don't, just boom. Wouldn't that accelerate things?
With no changes, no amendment.
Yeah.
But then we got to deal with it next year again. Same problem, and more
Well,
people will pile on.
But that would accelerate things.
I would note that it also adds a $700,000 hit to the OPLC in the fiscal
Yeah.
note if we leave it
Well.
as is, and I can't support that.
Well, relative to the $60 million we just spent on lunches or whatever, I say that's a mere bagatelle.
That's a different. We got to discuss this bill, not the bills. Yeah, so we may have difficulty passing it the way it is.
Just suggesting that would sort of, everybody seems concerned that we're going to run out of time here and
I think we
cause
just discussed.
bottlenecks, and we'll just pass it as it is. And
It seems like the governor would care about kids a lot and rush it through, and summer camps and everything else. So I think we have a good chance, as Mr. Clegg testified, to make the changes and pass it.
Read on what the changes should be, go ahead and do it.
I think Representative Galling has concerns.
And
About passing it.
I agree that the amendment we get from OPLC is sufficient, and I would also ask that if we amend this, that we remove the out-of-state pharmacy section with the at no cost. I think we've heard that, I don't think that's no longer needed from OPLC. So I think that would be, if we're going to do an amendment, to remove that section.
12 to 15, you said, right? Okay, thank you. And anything we can do with the date in section 3, January 31st, 2024? To not have such dates.
That's the date for what?
This is student licenses, right? Director, please.
Thank you, Representative. My suggestion would be to leave the date as January 31st, 2024, even though I agree that it's not a great opportunity, or it's not in the middle of a session. But the reason for that is I think this issue is going to be fit squarely within the study committee in SB 330. I think this is one of the issues that we have to look at as a state is portability. And that section 3 is really dealing with portability. So hopefully some things will come out of that study committee that will help inform, the legislature as to what changes need to occur. So I would suggest just leaving it as is.
Thank you. One more question. Line 28, section 10 of this act will take effect on the same date, 2024. What is section 10? And why is there another date? Do you know? Representative Gawley?
Yeah, it's hard to find because it's actually in Senate Bill 155 from last year, which has since been repealed prospectively pursuant to Section 10. So Section 10 is essentially prospective. It prospectively repealed the statute to on January 31st of 2022. This would change that prospective repeal to January 31st of 2024. If that makes sense. But you have to pull up 155 from last session and compare it.
Do we need this statement here, line 28 itself, which is section 10 shall take effect on January 31st, 2024? Do we still need it as part of this bill?
I think you would need it because there are other parts of that bill, that 155, that are not included in this bill. So I still think you would need section 10. Otherwise, you would still have authorization to continue to issue emergency licenses indefinitely, but all of those licenses would expire January 31st of 2024. So on February 1st of 2024, we could issue a license, but it would expire the day prior So there would be a statutory conflict.
Okay, so this fixes something in another bill, kind of. This line fixes something in another bill.
Yes, it eliminates the authority of the office to issue those emergency licenses. Yep.
Thank you. Hmm. Okay. Any further comments? So, well, so it looks like this, the OPLC draft legislation, the amendment is good to go forward.
Well, once it does, we're no longer fast tracking it. So then I guess you could pick a date out of the air that you want, one that works. If all the new licenses are being issued June 30th, then why not make this June 30th instead of January 21st, 31st or whatever?
But, so in section 1, we're striking the date, and it's being replaced here by this amendment. But section 3 and and line 28
I see.
still have that date, January 31st, 2024. I guess, should the 2024 be changed to something else? Is that the question?
Well, Representative Goley seemed to think it was important that it be 2023, but January 31st doesn't seem to work in 2023. Make it June 30th, 2023, and then it would at least align with all the other licenses. Yes.
So Representative Golly, I think, for section 3 and line 28 at the end, and or the director, should we change it to summer, June of 2023, instead of January 31st of 24? Both those dates that are going to remain. Yeah, we're good. Okay. Yeah, I believe so. So section 1 will no longer have a date. It will be replaced by the amendment, and then section 3's date will change to summer, June of 2023, and then line 28 date will change to the same summer, June what? June something of 23. Okay. Right? June 30th of 23? For everywhere, there's 24 right now. Okay.
Can you repeat that again? So I got the one for section 1.
Section 1 is the amendment.
Right, I got that one. But what
Sec-
was the? what
Section
was-
2 goes away. Line 12 through 15, we strike that.
Okay.
Not section 2, but line 12 through 15.
And
and then-
line-
And then line 24 and 25, the date changes to June 30th of 2023.
June, okay.
And then line 28, we changed the date also to June 30th of 23,
June 30th of what year?
2023.
Okay.
Please,
Which
Representative
would
Bailey.
align with the current licenses or the need to renew licenses, and it would give all the Senate and the governor time to deal with this, right?
Yes.
Yeah.
Okay. Are we? Any comments from anybody? No? Good. Audience. Any comments? Yeah, all good. I want to see if Carol, when she comes back, if she's got any input. So I'll try to get it drafted. Maybe we'll look at it today. Do we care that the fiscal note changes because of our adjustments? No. And the question, just procedural, technical question. So all of a sudden, all these temporary licenses get converted to regular licenses. Will the people know somehow that they got to go through the new process, the renewal? Okay, thank you. Please, Representative Phyllis.
So how do you notify them by email? You put it on the website.
You
You
wanna
gonna
come back?
mail them something in the U.S. mail?
We typically don't mail via US mail. The only board we're mailing for right now is Board of Barbering because we don't have their email addresses. Email for the remainder of the boards is part of the demographic contact information that they're required to keep up to date with the board. And our experience has been that when we mail things out via snail mail, not only is there a significant cost to that, it also requires a lot of time for staff to stuff envelopes and the like. We're talking about 22,000, and we get a lot of return email. We get a lot of return, so we don't typically mail out. And in this case, it's problematic because 15,000 of these individuals were mass licensed, bulk licensed, if you will, pursuant to an emergency order for because they were New Hampshire Medicaid enrolled providers practicing in Boston. So the OPLC does not have a full. We don't even have a full set of all of their contact information, their home contact information that's contained by DHHS, who facilitated the communication.
Follow up? Yes, please.
Yeah, so I'm wondering if when you send out the emails, if any of them bounce, if you follow up on that and then try the like regular mail, because things can happen, their internet provider can be having a problem or whatever, or maybe they just changed their email address and forgot.
Well, we send it out multiple times. For a traditional renewal notice, we send it out 60 days, 15 days, and then after expiration. It's incumbent upon the professional to keep their information current, and that actually can subject them to disciplinary action if they don't. So, as you can imagine, with 200,000 licensees and 18 license clerks, it would be pretty difficult for us to essentially micromanage people's contact information, which is why it's necessary that they do it. It becomes a problem when we have a disciplinary action and they haven't updated their contact information and we need to do an investigation. That's really why that technically is a requirement of an ethical requirement.
So I asked you if when an email bounces, you maybe revert to the U.S. mail, and is your answer no?
Correct. My answer is no. We do not have the capacity to do that.
And did I also hear that you have people that are licensed and you don't even know their residence? You don't even know their address where they are?
We have individuals who are issued an emergency license pursuant to an emergency rule. They are New Hampshire Medicaid enrolled providers, meaning that DHHS has access to all of their information.
Okay.
And we worked with our agency partner to issue them those licenses, and DHHS facilitated that communication.
Okay, so is your plan to move that data into your database?
Correct. That would be part of the plan if the legislature
Oh,
would move forward with converting those
okay.
licenses. But
Because
as
if they were just going to emergency for 2 years and that would be the end of it, then it kind of like didn't matter.
correct, and if you may recall, originally emergency licensure was supposed to be for a couple of weeks, right? We didn't anticipate this need for this transferring of all this data. So it has transformed into something else, such that now we need to plan to migrate the data.
A question to the director: can we put something in here to help you with that process?
can you give me like 400 more people? No, I think from a legislative standpoint, we should be all set. But I appreciate it.
Um, okay. You got a few minutes before we send it for amendment.
Thank
Yeah.
you, Representative.
Thank you. Microphone, maybe. I cannot hear.
We're waiting on an amendment, but that'll come
Uh,
this afternoon or something?
Well, it takes a while, yeah.
Yeah.
But I really want to submit it. Yes, Representative Golly. Say it again. Do this again next Monday.
Can we
the amendment?
schedule for next Monday morning if we have here, I believe we might have hearings Monday. If we could meet at 9 o'clock to review the amendment and pass it. I mean, it's not going to go forward to the House until the May 5th, so we still have plenty of time. But if we could review it and get it before the committee next week for an exec, then it would be on its way.
Yeah, but maybe we can get the draft today, even. I don't know if we can get it by the end of the day. No. Oh, that's too much. I got you.
I think if we just put it in for Monday at 9:30,
Okay.
would give us plenty of time, give them plenty of time to get it together and make sure it's correct. And then hopefully when we meet on Monday, we have time to do some execing and we can move this through to get it ready for the next House session on May 5th.
You're saying the subcommittee. Do a subcommittee on the Monday. Okay. Yeah, Monday, next Monday. We're here. We're doing the full committee on next Monday also. Maybe a Tuesday. Okay. Okay. So, but yeah. But yeah, I'll ask to have it drafted today, and whenever we get it, we'll look at it, and then so plan for Monday, 10:30. Is it? Yes,
I
please.
think that there might be another subcommittee having a subcommittee
Okay, yeah,
meeting at
that-
that time, but we can we just,
I'll check with the with the secretary. Yeah. Okay. So next Monday.
I can't hear.
Sorry.
And here I was just thinking of us. Good thought.
So let me go over the changes once more. All right. Yeah. So we're good. So section 1. Section 1. Thank you. We haven't started yet, but yeah. Thank you. Section 1 is replaced by this draft amendment from the OPLC we got. Right? Okay. The whole section 2 is gone from line 10 to line 15. Right, Representative Golly? 10 to 15, 10 through 15.
Yes.
Inclusive, okay. Gone. Section 3, the only change is lines 24 and 25. The date of January 31st, 2024 changes to June 30th of 2023. Agreed, I guess. Yeah, good. Okay. And then
And I have one more question. I don't see the director here. The only question I have is if we removing section 2, if you go down to line 26, it says emergency licensing procedures and out-of-state pharmacies. If we're taking that out, we may need to strike out out-of-state pharmacies on that line. That's,
okay, that's a question. Okay, I can.
she's not here, but that would be a question I would ask. I think we can remove that.
if 2 is gone, does that disappear also? Okay. And then the last change is line 28. We're changing it to June 30th also of 2023. Okay. I think we're done. Yep. All right. If no more input, thank you. We're done with subcommittee. We'll continue next Monday with the draft amendment ready. Thank you.
Good morning, everyone. Welcome to EDNA. I'm opening the hearing on Senate Bill 274, and I call the prime sponsor, Senator Bradley.
Good morning, Madam Chair and members of the committee. Glad to be back here again. For the record, Jeb Bradley from Wolfboro, and I'm pleased to be here to be the sponsor of Senate Bill 274, which passed the Senate earlier this year. Just on a general basis, this is a bill about competition. It's a bill about fairness, and it's a bill about transparency. Unlike past efforts regarding project labor agreements, this bill only applies to state projects. There was a bill a year ago that applied to state and local projects. That any local projects has been eliminated from this bill. In New Hampshire, I'm told, and you'll hear testimony on this fact later this morning, that 90% of people who work in the construction industry are not unionized. And so what a project labor agreement does, it requires, if the state requires it, for collective bargaining for a project labor agreement on wages, on benefits. And so in essence, it creates favored treatment for the 10% of the workforce that in the construction industry is unionized. The Senate heard testimony, and I'm sure you'll hear the same testimony, that project labor agreements tend to drive up costs, and that's certainly something that we should be concerned about as we're trying to protect taxpayers, especially with a lot of new infrastructure dollars in New Hampshire. So let me just walk you briefly through the bill. The purpose statement is, as I articulated, it's about fair competition. And it says on line 5 that the state shall not include project labor agreements as part of a competitive bid process. So if you look at line 18, it defines government entity as the state. No other public entity, it's state of New Hampshire contracts. On line 22, it defines what a project labor agreement is. It's something that establishes the terms and conditions of employment for a specific construction project. And then it gets into the meat of the bill starting on line 25, where it says no state, again, government-assisted project shall include the following in its bid specifications. And then it continues on to page 2 as to what is not allowed in the bid requirement. So a prohibition for a project labor agreement is articulated on lines 1 through 7. However, and I want to be really clear on this, what it doesn't do, if a contractor wants to have a project labor agreement that they have entered into with a union set of construction workers, there is nothing in this bill on a state contract that would preclude it. What it precludes is the state mandating project labor agreements. And you can see that starting on page 2, line 9, and in particular on line 17, where it says you can voluntarily enter into a project labor agreement. There is an exception on line 27 if there are special circumstances and a finding that is required. So that's the nuts and bolts of the bill. I think it's a fairly simple bill. It's narrow in that it only applies to the state of New Hampshire construction projects, and I hope that this committee will go forward with it. Thank you, Madam Chair.
Thank you, Senator. Are there any questions? Representative Marsh? Thank you, Madam Chairman. Thank you, Senator, for coming to us and presenting this bill to us. I have a question particularly about the meaning of government assisted on lines 20 and 21 on page 1 of the bill. In particular, that refers to RSA 79E, the Community Revitalization Tax Incentive. Would I be correct that that would include the Economic Opportunity Zone in Manchester, centered around the Notre Dame Bridge, where the Advanced Regenerative Manufacturing Institute is currently located, making that project a government-assisted project?
I am not sure of the answer to that, Representative Marsh. I think it would be best to ask other witnesses that will come behind me.
Follow-up
You
question?
follow up?
I believe that we'll hear that later on. We know that the city of Manchester recently received a $500,000 from the Build Back Better Regional Challenge Program to plan establishing a cluster in that area. And they're currently competing for a $100 million grant in phase 2 of that. I happened to get the notice of funding opportunity executive summary, which I would be glad to share. And I note that on page 21 of this grant that they've applied for, it is required that they get a detailed plan on how the coalition will engage community-based organizations and or labor unions, how the project will incorporate strong labor standards and economic benefits for local residents, including project labor agreements and community benefit agreements that offer wages at or above the prevailing rate and include local hire provisions. My question relates to this project, which I had thought you were in favor of. Is it your intention to make it less likely that the city of Manchester and their partners will receive this grant, or possibly make it?
Representative Marsh, we cannot question intentions.
Ah,
You should ask, would the effect of this bill be to?
okay. Would the
And
effect
I'm
of
going
this
to
bill?
answer that question, Madam Chair. If you look on Representative Marsh on line 18, government entity means the state. I think you're referring to a City of Manchester project.
Thank you. I think the question relates upon the what the definition of government assisted is, which I asked you before. I have one other follow-up question, Madam Chair.
Follow up?
I think we all can agree that the Department of Transportation is a part of the state of New Hampshire. And the Department of Transportation also competes for discretionary grants. I have in front of me notice of funding opportunity for the Department of Transportation's National Infrastructure Investment, the Rebuilding America Infrastructure with Sustainability and Equity Grant Program. And I note on that, on page 25, that again, these grants require the use of project labor agreements. Would this bill make it less likely that the New Hampshire Department of Transportation would successfully compete for such grants and make it unable for the state to actually build these projects?
I don't believe so.
Thank you.
Are there any other questions for the senator? Oh, Representative Goley?
Thank you, Madam Chair. Thank you, Senator, for taking my question. Can you tell me if the state of New Hampshire has ever had a PLA agreement?
My understanding is that the state of New Hampshire has never entered into a PLA, but with all of the infrastructure money that's floating around the state of New Hampshire and some of the surplus dollars that we're allocating for different projects, I think it's very important that we enact this legislation to protect taxpayers. As I think you would probably be aware, according to information that I've seen, the Job Corps Center in Manchester had more bidders after a project labor agreement was not adhered to, and the cost came in at, I think it was about 15% less because of open competition. I think that's what we're trying to establish here.
Follow-up? And a follow-up is, with all the money coming in the transportation, the 1.3 billion from the federal government that's being dispersed, trillion that's being dispersed, are projects with PLAs giving a higher grade and a higher, greater ability to get some of those projects if they include PLAs?
I'm not aware of that. Again, this only applies to state contracts. And again, I would hope you would join me in the intent of trying to make sure that 90% of the workforce in this state that is not part of a union has as much access to the ability to actually do the work and do it on time and hopefully under budget and at less cost to taxpayers. I think that's what this bill is about.
Follow up, Representative Goley?
I just want to follow up on that comment. Are you saying that the 10% will always overbid the 90%? And
I
they are
think
not
that you will
competitive?
hear from other witnesses that will come after me that are in the field, in the construction field, that can offer that kind of evidence. I think the Senate heard testimony that project labor agreements generally cost 20% more than construction projects without a PLA.
Representative O'Brien?
Thank you, Madam Chair, and thank you, Senator, for taking my question. In my high school years, I went to Don Bosco Technical High School in Boston. And then from there, I went to Massachusetts Maritime Academy. I feel at Don Bosco, they gave me college prep and they also gave me a trade. I feel that in my life experience, I done better with the trade than I did with the college education. In this particular bill, by eliminating the potential of unions, which has journeymans and quite an exhaustive process to which a person can come in, join the union, learn that particular trade, and become an expert, true professional in that trade. By eliminating that 10%, are we doing the state and perhaps even municipalities a disservice by having less than qualified labor and working in this? For is it not most labor standards copy or mirror the requirements that like a trained journeyman or a licensed plumber or something like that would follow?
So let's go back to the bill, okay? And if you look at page 2, line 17, there is nothing that prohibits a contractor themselves from entering into a project labor agreement if they choose to do so. There may be reasons that they would want to voluntarily do that. All this bill does is say the state should not enter into a project labor agreement. And I think given that we want to have benefits for taxpayers, get projects that will have more bidders and free and open competition, that's appropriate to protect taxpayers. On the other hand, the fact that a contractor can enter into a PLA and it has nothing to do with the counties or the state, or the counties or municipalities. It's only the state. This is not undermining labor unions. They'll still be able to have project labor agreements, but it has to come from the contractor.
Follow up? Well, that's kind of what I'm kind of talking about, because by this particular bill, it would eliminate a labor organization from participating to 10% per se.
No, I
in
don't
this.
think that's the case, sir. It's not
So
the case
then-
at all. It would just say that the state could not demand a project labor agreement. There is nothing that would prohibit a contract or a contractor working for the state that voluntarily wanted to do that because they felt it was the best thing to enter into a PLA from doing it, but it would say the state is not going to set it as a precondition of getting that contract. So that's where the free and open competition comes in.
Follow up, if I may? Well, in the bidding process, is that part of the free and open competition currently does exist? Why do we need this particular Band-Aid?
Well, I think I've answered that question already.
Okay.
Representative Groda?
Thank you. Senator Bradley, this is a little bit new to me, so my question was very similar to how Representative O'Brien's question. Why is this bill needed? And I'm sorry if you've answered that question. It went through one ear and out the other. So if you could kindly repeat it, I would appreciate it very much, because we do not require these PLAs now. Is that correct?
To the best of my knowledge, there haven't been state requirements for a PLA. That being said, what this would say is the state is not going in the future to require a PLA because of the reasons that I articulated. That 90% of the workforce is non-union. PLAs generally are higher priced. That's why.
Follow up?
Follow up, Representative?
Thank you. So if we're going to say that the state's not going to require it, but the contractors can require it, I don't understand the difference.
If the contractor, because remember, the contractors are bidding on state contracts. There's usually an RFP that's put out. We want to get as many bidders as possible to get the best price and the best quality. That's generally how state contracts are awarded. If a contractor themselves believes that they can put together the best bid using a project labor agreement, nothing in this bill would preclude that. What it doesn't allow is the state to demand as a precondition a project labor agreement. So it's very different. If a contractor themselves want to do it because they feel it's in the best interest of winning the bid in terms of price, quality, ability to get work done on time, they can do that. There's nothing that would prevent that.
Representative Fellows, did you have a question?
Thank you, Madam Chair. Thank you for taking my question. So I'm not really expert in this area either, but I know that the state will issue an RFP for a contract that uses all or partly federal money. So does federal money ever come with a requirement to do this, or something like a preference for related to labor unions?
I mean, that could be a term and a condition of a federal award of a grant. My understanding is that there's been some discussion about projects that are over $35 million would have to conform with the federal bid process. That's my understanding, but you'd be better advised to ask that question of later witnesses.
So I have a follow-up to that.
Follow up?
So the other half of the question, that's on one end. So I'm going to look at the other end also. The state awards money to municipalities for things like, wastewater treatment and roads and stuff like that.
They would not be impacted. That would be a municipal.
But I'm concerned that this bill might do that because that the municipality would be doing the contract, but it would involve some money from the state. And on line 27 of the first page, it says no state government assisted project, which to me sounds like assistance of state money.
So let me just say this. If the committee wants to clarify that, the intent of the bill is that it is state contracts. And if the committee wants to clarify that, I would not have a problem with that.
Last follow up, Representative.
So it doesn't strike me that the wording of the bill says that, but is your intent that this only applies to state contracts using 100% state money?
That was, as the bill was brought to me, the intent.
Are there any other questions for the senator? Seeing none, thank you very much.
Okay, thank you, Madam Chair.
You're welcome. Representative Davis?
Good morning. Thank you, Madam Chair and members of the committee. For the record, my name is Arnold Davis, representing COAS District 2. Also, as a freshman rep, this is the first time I speak in front of a committee. So if I develop a stammer or facial twitches, I'm not having a stroke, I'm just a little nervous. I'm here before you today to voice my opposition to Senate Bill 274 relative to governmental construction contracts. Senate Bill 274 is a bill that is a solution in search of a problem. Not only that, but if passed, it is a solution that could mean New Hampshire losing millions of dollars in federal funding for infrastructure that our state desperately needs to repair its roads and bridges. Supporters of Senate Bill 274 claim that this bill will foster competition and will ensure that taxpayers are getting what they pay for. In reality, this bill, if it becomes law, will make a process of bidding on the state construction projects less competitive by favoring contractors that are paying their workers less. There is nothing in the bill that guarantees competition or even that New Hampshire workers will be employed to work on the state-funded construction projects. What is most troubling about this bill is the unintended consequences that will result if it becomes law. Right now, New Hampshire is in desperate need of funding to repair our infrastructure, and passing this bill into law could result in our state not being selected for federal infrastructure funding awards. The bipartisan infrastructure law that was passed by Congress and signed by the President lays out the criteria that will be evaluated to choose who and where federal infrastructure funding will be awarded. And one of the elements for deciding where this funding should go are labor standards and project labor agreements on proposed infrastructure projects. I have serious concerns about passing a bill that would right off the bat diminish New Hampshire's chances of receiving badly needed federal funding. In the North Country, infrastructure money is probably needed more than anywhere else in the state. And the fact that the sponsors did not take into consideration that passing this bill could hurt our chances at receiving this funding is reason enough for us to oppose it. But I also believe we as legislators should be supporting bills that seek to solve problems that our state is actually facing. And as New Hampshire has never had a PLA, this bill seems only to add to governmental red tape in further regulation of the New Hampshire construction industry, where New Hampshire has never mandated a project labor agreement for a state-funded construction process in its history. Why are we being asked to pass a bill that would prohibit something that has never happened? There are far more pressing issues that need to be addressed by the legislature. Passing Senate Bill 274 to benefit one group of contractors is not a good enough reason to jeopardize millions of dollars in federal funding for infrastructure or to tie the hands of the state from using an efficiency tool like a project labor agreement in the future. We should not be in the process of picking winners and losers, and that is what this bill will do if it becomes law. I respectfully ask you to vote ITL on this bill and not to risk our chances of receiving funding that my community desperately needs. Thank you.
Thank you, Representative. Representative Schmidt?
Thank you, Madam Chair. Representative David, Representative Davis.
You can't escape the hot seat that fast, man. Not on your first shot.
Yeah, I'm not going to be answering questions. I believe there's people here far more qualified than I am, if that's okay.
Absolutely. My apologies.
No, fine. Thank you.
Representative Schmidt will, hopefully you'll be able to ask your question to the next person that testifies.
Well, Representative Davis, the fact is you've read us a statement. Have you provided that to the committee, or are you willing to do so? You read us a statement, clearly a prepared statement. Are you willing to provide that to the committee?
Yes.
Okay, very good. That's my question.
Okay, do I,
Senator Khan, all right. Yep. Mr. Gola,
Gullah.
Thank you, Madam Chair, members of the committee. Thank you for allowing me to speak today. For the record, my name is Richard Gulla, and I am president of the State Employees Association of New Hampshire. We represent nearly 11,000 members here in the state. I am here in opposition to Bill 274. To be blunt and direct, we do not need or want extra government red tape. This isn't the New Hampshire way. We should always work to get as much of our federal tax dollars back. We want to build bridges, fix problems, and support bipartisan infrastructure projects. This bill will not bring a single extra penny to our state coffers. As president of the SEA, trust me when I say our state faces rampant vacancies. For example, the New Hampshire Department of Employment Security has over 700 vacant job listings for skilled workers in construction. It's been difficult to find workers because this economy, workers can choose to be very selective. Workers want good, paying jobs with benefits and protections. Let's kill this bill and increase the chances of more federal dollars returning to the Granite State. Thank you.
thank you very much. Are there any questions? Representative O'Brien?
Thank you.
Mr. Gulla, are you okay to take some questions?
Maybe, we'll see.
Okay. Thank you, Mr. Gold, for taking my question. We heard in this House a similar bill, kind of similar in a way, that would have stopped any state funding into a rail project, something near and dear to me from the commuter rail into New Hampshire. That affects the DOT workers that you may represent. And now I'm looking at this particular bill, and it seems like New Hampshire can't see past its nose the benefits of true infrastructure and revitalization into this community, to how much it can help the state raise money and try to help to alleviate some of the burden with the taxpayers. So therefore, I don't know, this is kind of a loaded question, but is this kind of like an anti-worker type of situation that we see out here by some members of this legislature to against the state from actually growing and thriving and becoming...
Representative, please don't speak of other representatives' intent.
Thank you, and I apologize, Madam Chair, for that.
Thank you.
It's just that it was just a more than casual observation, excuse me. But I'll leave it at that if you want to opine on what I had to say.
It certainly feels that way.
Thank you.
Are there any other members that have any other questions? Thank you very much.
Thank you.
Mr. Abbott?
Thank you.
Thank you, Madam Chairman. For the record, my name's Gary Abbott. I'm the Executive Vice President of the Associated General Contractors of New Hampshire. I have distributed a position paper along with the history of government mandated labor agreements in public construction, white paper from our national organization, so you can have that information to make sure that you completely understand what we're talking about as far as labor agreements. I think Jeb Bradley did a great job in his testimony. I look at this bill, we are in support of this legislation, as it does one thing: it protects New Hampshire contractors, whether it's union or open shop. When these PLA agreements come under the federal government that has recently been talked about, those are federally controlled projects. they're administered by, say, the Army or the National Guard. Those are administered by those federal governments. If they require PLAs, they pretty much rule out New Hampshire contractors from doing the work. This bill is a protection bill of New Hampshire contractors. And I plead with the committee, that's what this bill is about. This bill isn't about separating union from open shop. I represent some union firms as well as open shop firms. And what we're trying to do is preserve the free marketplace in New Hampshire. We're trying to maintain that the companies that work and live here are maintained in the future. This bill limits it to state projects. Now, I know there's some language in here that needs to be changed in order to make sure it's very clear. I know the language that was used in the Buy America Steel bill that you heard had language that said state administered projects. That may be better language used in this bill. I'm just throwing that out there as one who's looked at a number of these bills. I think the intent was to move away from municipal projects, which a number of people have raised those questions. This bill just says, and it says this, other states have adopted similar bills. More than 20 other states are adopting bills like this, and I believe it's a protection of the construction industry in the sense that the government shouldn't mandate put conditions on a project that limit the scope of who can bid on the projects based on labor issues. That's really what this bill is about. So I would ask that the committee support this bill. I think it goes a long way in doing open and fair competition in New Hampshire. I think you will find that other states are moving in this direction because if a PLA was put on a state project, most likely we'll get out-of-state contractors that'll be doing the work. And some are okay with that, but as far as the construction industry, we're putting in place something that has been a common practice. The practice has been, and we have not had PLAs, to continue that. No one has given me a good reason so far. I don't think it'll stop the money. It doesn't matter about the state authorizing us. I have not seen that condition. But I think if you were to change some language to state administered projects, it would be very clear that you'd get rid of some of this state assisted, which kind of opens up the gray area. But that's my recommendation. And I appreciate the time today to testify before you. But this is a bill in which it looks ahead that these things may come to New Hampshire, and it sets a policy.
Thank you very much. Are you willing to take questions?
I am.
Representative Schmidt.
Thank you, Madam Chair. Good morning, Mr. Abbott. So if you recall, because I know you've been in this business for a long time, the state legislature re-roofed this very building about 15 years ago, and there were a lot of problems with that process because, without getting into the details, so we wound up with a lot of difficulties in getting the project completed, and I'm sure you recall that. So is this bill, as it's currently, or even with your amended version, is this bill likely to put us in a situation that is favorable or unfavorable in terms of our past experience with construction projects?
Well, it would make no changes to what's currently in the regulations. But you have to understand, construction, we're not talking about qualifications and pre-qualifications that are required. Like if you go to work for DOT, you have to be pre-qualified to do the type of work. If you're in asphalt, they have to pre-approve you to do that work. You just can't come in and not be skilled at that work. So there are things and protections under the current laws that help the state with making sure that they get qualified contractors. This in no way does that. This is about the preference of a contractor, whether he wants to enter into a legal labor agreement or not is his option. But the state can't mandate it to eliminate 90% of the marketplace. That really is what about this. This is really what this bill's about. It's not about the qualifications and the other requirements that are currently in place. This doesn't remove any of those. This has to do with labor agreements. And so I just want to make sure you completely understand it. That's why I put the white paper in front of you, that you can kind of understand the entire process.
Follow up, Madam Chair.
Follow up, Representative?
So there's been a reference to the fact that some 20 other states are currently, involved with legislation of this sort. Do we have any idea whether any of these other states have experience with the impact of this type of legislation in terms of how well that works in actually, benefiting the contractors and the state and the people thereby? Or is this all brand new legislation across the board?
No, more than 20 states have had it in place for, I know, at least more than 2 years, and have not heard any negative responses to having that in place in those states.
Thank you.
Representative Goley?
Thank you, Madam Chair. And thank you for taking the questions. So my understanding is, and if you could just confirm, that the state of New Hampshire has never required a PLA in any of its contracts?
Not that I'm aware of. Only the federal project of the Manchester project, in which that went to court, and then the project labor agreement was moved for the Job Corps Center. So it's just something that has highlighted this issue for New Hampshire contractors that went through that process. We don't want that process to happen for state-funded projects.
Follow up. And you also stated that there are some federal contracts out there that require PLAs, or there may be money tied to a PLA for the state of New Hampshire to receive, or a PLA requirement may move you up on the list on whether or not the state receives money, funding, or granting. Is that correct?
I don't know of any state money that has required that the state administer a PLA project. The reference to the federal government, President Biden did an executive order in February, was an executive order on federal projects over 35 million. But that's not money that comes to the state. It's administered by those federal agencies. And it's problematic for New Hampshire, but we don't get very many 35 million plus projects for federal projects in the state of New Hampshire. Those would be things like the courthouse and the others that are already built. So I hope that clarifies we are not aware of any requirement that has come down that has a state agency saying they have to require it.
Follow up.
Representative?
But in the earlier scenario I put out, there is a lot of money that is set aside, ready to come here to New Hampshire for projects. I know specifically in Manchester, we have money that we are bidding on, sent for projects that we sent in and submitted to for the federal government to receive funding. And those projects may have a PLA in them, and when we bid them out in Manchester, and my understanding is this could affect that money as it comes through. So as a requirement, does that not affect, this legislation would affect those projects?
Well, I think if you change it to what I talked about earlier, to state administered projects, if that federal money comes as a grant from the feds to the town, it's not a state administered project.
Representative Groda, did you have a question?
Thank you. Mr. Abbott, if the state doesn't require it now, I guess I'm struggling as to why we need this bill. Because if it doesn't change anything and we don't require it now, why do we need to do this?
Well, I think it's a clear policy for the state to make for all state agencies as far as when this question comes up. Otherwise, we'll be back here when the first one starts, and I think it's a good policy.
Follow up, Representative?
Thank you. So, as a second term state representative, I can tell you we get a lot of bills. And so maybe it's become my personal mission, but I think we should really seriously look at bills that help Granite Staters and the state needs. And if we're setting a policy that already exists because we don't mandate this. So I don't understand why you're just putting a lock on another lock on a door, correct?
I look at it like I started out in my testimony is you're putting in place a protection for New Hampshire businesses.
Thank you very much.
Thank you. Representative O'Brien?
Thank you, Mr. Abbott, for taking my question. You said for protection of New Hampshire businesses. Perhaps, as you know, I come from the firefighting ranks, and when I was in the Committee of Transportation, we came out with license plate for firefighters, and I says, well, what would guarantee a firefighter? How would you know? And said, perhaps maybe having the qualification and education such as firefighter too. And I come to find out in this state that you can call yourself a firefighter, yet not really meet the same qualifications that I had to meet within the city of Nashua. So therefore, removing the safety bar of union involvement, which has very high standards of method of operations and training and everything else, such as you mentioned, even in the field of asphalt, to make sure that somebody that works for the DOT is certified to lay down the asphalt. Are we not, perhaps with this bill, removing a potential safety bar of guaranteeing construction projects within the state?
We are not. The state of New Hampshire has put in places regulations that require like 10-hour OSHA classes for construction as a mandatory for workers. There are other requirements that are already in place that put in place for whether you work for a union firm or an open shop firm. And there are requirements within the industry regarding different fields. So I don't believe it has anything to lowering the bar of any kind of safety.
Representative Goley?
Thank you, Madam Chair. I just have to follow up real brief on a statement you made about trying to protect New Hampshire companies and workers. Are you telling me those that are labor organizations are not New Hampshire workers or companies?
No, I guess what I want to clarify is, I'm going to put it this way. I represent both union and open shop, and they can compete currently within the New Hampshire marketplace. They compete on similar jobs. But most of the contractors who have labor agreements, that have chosen to have labor agreements, have them for individual trades. Their whole company, in most cases, are not union firms. They are union signatory on a project and a project basis and signatory to certain crafts. Even those that I'm classifying as union do that on occasion. That is their choice, and I think that is what we're trying to protect. That is their choice, not to have the state mandate that through a contract, forcing all the other contractors who don't want to do that. But I'm saying it protects the marketplace that we have that seems to be functioning fine. We don't have really complaints, and this really is to put in place what we've had for a standard over all these years.
Thank you very much. Are there any other questions? Representative Schuett?
Thank you, Madam Chair. Thank you, Mr. Abbott, for taking my question. The fact that many New Hampshire contractors don't have large unionized workforces, is it not partly because, excuse me, of the practice of designating some of their employees as subcontractors rather than as employees?
I think we will find on most contracting projects, there are subcontractors. I guess I'm not really following your question because I think that's a standard practice that If you build a building, you're going to have electrical contractors, you're going to have plumbing contractors, you're going to have many different fields. The project labor agreement would be for the entire project and could have trouble with subcontracting as well.
Thank you very much. Are there any representative fellows?
So thank you. So I thought I understood, but maybe I don't understand anymore because, I know that electrical workers, have a union and those contractors. I think we're talking about the big contractors that subcontract most of their work. So those big contractors, which I think are what you represent, they don't actually, do they actually have a contractors? I don't even know what to call them. Are those the general contractors? Or?
Yeah, there's a general contractor who usually bids on the project. And he gets quotes from subcontractors to do various portions. The general contractor may do portions of the work themselves. So the agreement, the contract is signed with the state agency after they bid and they're the low bidder and they go through the executive council process. They're the one responsible for the job.
Follow up?
So now I'm wondering if this bill even works, because if somebody bids on a project, it's that big general, I don't know if general contractor is the correct term. So general contractor, I mean, it's not the electricians that are bidding on it, it's the general contractor. And I think that you're saying that general contractors are not a union. So does this apply to anything?
If you put a project labor agreement on the project labor agreement usually requires everyone on that project to follow those individual rules that are placed in by the agency. So it would apply to everyone on the job. Right now, you're absolutely right. Some companies, the plumber may be unionized, or they may not be. But the contractor right now selects those subcontractors based on their qualifications. Are they available? Workforce, can they do it in time? Those things are all handled by the general contractor, but it's the general contractor who signs the agreement with the state and puts up the bond and all the insurances to complete the project.
Thank you.
Thank you very much. Are there any further questions? Thank you very much.
Thank you.
Ms. Brines?
Good morning. I'm Margaret Burns, Executive Director of the New Hampshire Municipals. It happens all the time. The worst one I've ever heard is Beernez. So Brines I can handle.
I actually asked, like, is this Burns or Brines? And that was...
Good morning. Again, I'm Margaret Burns with the New Hampshire Municipal Association, and we are opposed to Senate Bill 274 on a very narrow basis. Clearly, the intent of the legislation, based on the prime sponsor's testimony and testimony that has come before me, is to apply this policy to state projects, not to municipal projects. And in fact, in the Senate, the bill was amended to add some language to the definition of governmental entity on line 18, that it does not apply to political subdivisions. However, our concern remains with the definition of government assisted in lines 20 through 21, which does refer to any project that receives a tax exemption, tax abatement, or tax credit under RSA 72, section 80 through 83, RSA 79-E, or RSA 162-N. Specifically, RSA 7280 and 79E are local options for different types of local projects, as Representative Marsh and I believe Representative Goley have already referenced. 79E is the Community Revitalization Tax Relief Incentive Program, and RSA 7280 is the Commercial and Industrial Construction Exemption, and both of these are local options, so they would only be local projects. My concern, therefore, is not only that this bill could be applied to local projects, but that it also creates some internal conflict in the statute. Does the statute apply to local projects or does it not? And I think that's the issue raised by keeping the definition of government-assisted project as is. To be clear, NHMA has no position on whether or not municipalities should enter into project labor agreements. Our opposition is simply based on the fact that municipalities should be able to make these policy decisions for themselves about their own local projects. And for that reason, we are opposed to the bill as written. Happy to take any questions if I can.
Thank you very much. Representative Marsh?
Thank you, Madam Chair, and thank you for taking my question. Could you kindly answer my question about the project in Manchester where they're currently applying for $100 million, which would include the Advanced Manufacturing Regenerative Institute?
I believe the project fell under RSA Chapter 79E that you referenced, and so under the language of this statute, under the language of this bill, it would fall under a government-assisted project, so I believe it would fall under the parameters of this legislation.
Thank you.
Thank you very much. Are there any further questions?
Thank you, Chairman.
Bailey.
We've heard from several witnesses, including you, that this is a problem because it binds the hands, in your case, of the municipal people below us. But isn't it also a problem that we are being bound by the federal government above us? I mean, shouldn't it be like we should have this bill at all levels?
Our position would be no. Not only should we not have this bill at all levels, we should not have legislation that binds the hands of municipalities either way. To be clear, in the past, NHMA has also opposed legislation to require the payment of prevailing wages in local construction projects because we believe that municipalities should make those local decisions at the local level.
Thank you.
Thank you very much.
Thank you.
Right. Ms. Hokinson? It's Hawkinson. I shouldn't be allowed to read these.
As long as you consistently butcher everybody's name.
Consistently, without doubt.
Thank you, and you got my name correct, which is great. Doesn't happen
Thank you.
very often. And I'm a first timer as well, so I apologize for reading, but I will be doing that this morning. Good morning, Chair, and the remaining members of the House Executive Departments and Administrative Committee. My name is Kim. Oh yeah, sorry.
You can just lower it down to a little bit. That would help.
And that goes for everybody. You kind of have to eat the microphone for the folks on YouTube to be able to hear
Is this
you.
any better?
It's awesome.
All right, we'll try it again. So, good morning, everyone. There we go. My name is Kim Hokinson. I live in Nashua, New Hampshire. I am a 16-year member of the Carpenters Union, and I am here as the Northern New England Regional Manager. So I cover Vermont, Maine, and New Hampshire. I represent locals 349 and 352 of the North Atlantic States Regional Council of Carpenters. Very long name. I am proud to be here on behalf of our union members, more than 2,400 in New Hampshire, and I'm here to speak in opposition of SB 274. First, our union supports PLAs because they benefit everyone on the construction site, from the developers to the contractors to the workers and to the taxpayers. Our public work projects, like you suggested by this bill, all contractors, union and non-union, are invited to bid. Non-union contractors can be found on PLA projects. PLAs simply create a level playing field for all contractors because bids must pay the same labor costs. This means the winning bidder must demonstrate cost savings that truly add value rather than simply paying their workers less. Secondly, PLAs create jobs that provide family-sustaining wages, training, and safe working conditions. Sadly, today, rampant wage theft and misclassification of workers in our industry have driven down wages and benefits. As a result, a recent study has shown that more than 40% of construction workers, 40% nationwide, must rely on some sort of public assistance. 40% rely on public assistance. By using PLAs, we know that the workers on the job are paid fairly and they have access to industry-leading training, like the training that we can provide at the Carpenters Training Center in Manchester. This in turn benefits not only the workers, but also the state taxpayers. Finally, PLAs benefit contractors and business owners because they know that they have a level playing field when they're going to bid a job, and they are successful that they know that they have access to these well-trained, safe, reliable workforce to ensure that the projects are built on time and on budget, like we've heard. Thank you for the opportunity to speak, and I urge you to vote against SB 274. Thank you.
Thank you very much. Are you willing to take some questions if there are any?
I'll give it a shot.
Thank you. Representative Schmidt?
Thank you, Madam Chair. You appear to be reading from a prepared document. Have you provided that to the committee, or are you willing to do so?
Absolutely willing to do so. I have not yet.
Thank you.
Thank you very much. Are there any further questions? Representative Schuett?
Thank you, Madam Chair. Ms. Hokinson, would it be fair to say that the workers that would work for these companies are also taxpayers?
I would say that's fair to say, yes.
Thank you.
Thank you very much.
Thank you.
Mr. Clegg?
Thank you, Madam Chair, members of the committee. I rise to speak against this bill. As someone who's been in the contracting business since I was 15, I can tell you that one, it's not necessary, and two, all it does is encourages the cheaters to find more loopholes. In all my years in the business, and by the way, I'm 68, it's been a long time, I can tell you that when you decide that you're not going to have any kind of a PLA on a big job, all you get is the people who aren't paying workers' comp, aren't paying their people the going rate. I was on a job recently where I noticed some of the roofers weren't eating lunch. I needed an interpreter to ask him why. Didn't have his green card, so they were paying him $7 an hour. I've also been on jobs where they do have their green card, but they're so afraid to say anything, and you find out they're not getting the $35 an hour that the rest of the guys are getting to do that roof. And what did we do? On my job, I threw them out. Not the guys that didn't have green cards, but the contractor, because that's not the way we do things. We require that you pay your people, that anybody who's working there has to be legitimate, and that nobody's abused. We right now have jobs going on in the state of New Hampshire, large jobs paid for with taxpayer money, where the contractors come from either Vermont or Maine, where the workers' comp is cheaper. They don't follow our rules here, which says you can only work 3 days here before you have to have a New Hampshire workers' comp. They just keep saying, oh, well, I left and I came back, because their rates are so much cheaper than ours. So basically, the idea that we're going to save some of the New Hampshire contractors is a fallacy. We're not saving anybody, because right now we're allowing the abuse. And it's every single day. As I said, we in our company pay workers' comp, we follow the labor laws, and we have safety requirements. And everybody is our employee. You're right when somebody asks the question, how easy is it to make everybody a subcontractor? It's very easy. All you say to them is, here's what you get. And you know the worst part about that is those guys don't know enough to save enough money to pay their taxes that they owe. So at the end of the year, they're looking for their unemployment tax and everything else. They didn't make any money. In fact, on one case where I tried to help somebody, when they finally paid their taxes and everything else that the state came after them for, they actually made $5.75 an hour. Not even minimum wage, but what they were offered looked really good until they got caught. So I'd ask you to not bother passing this bill. It's not necessary. And to say that a state can't have a project labor agreement, it just says, here's what you have to follow. Here's the rules. Everybody has to be paid right. They have to have their workers' comp. You have to have their FIDA, FUTA, SUTA, all that stuff has to come out. And you can't make them a subcontractor because it's cheaper. As I said, I've been doing this a long time. I'm probably one of the few people in this room who have actually run very large jobs and had both union and non-union people working side by side. But on my jobs, everybody's paid the same. So the only arguments we ever got into is who was the better craftsman. And I appreciated that because that meant that everybody was trying to outdo the other to be even better. To take away the PLAs, or my right to have a PLA, is to take away the idea that everybody's going to have a fair opportunity and every contractor can actually bid knowing that they're not going to be outbid by the guy who cheats on a regular basis. Thank you, Madam Chair. I'll take any questions. It's not my first time.
Representative Goley?
Thank you, Madam Chair, and thank you for taking the questions. Being around long enough, we hear PLAs could be increased costs on a project up to 15%, somewhere in that range. In being around in construction business long enough, does a low bid always mean a quality project, quality completed project?
If somebody's 15% less, typically what happened is they've forgotten something or they have a plan on not doing something. And if you want to talk about asphalt, instead of 3 inches, you're going to get 2.5. There's all kinds of ways of cheating the system, and cheap bid's not always the best bid.
Representative Fontenot?
Thank you, Madam Chair. Just for the record, could you state what your name is and either what company or
I'm sorry.
organization you represent?
My name is Robert Clegg. I live in Hudson, New Hampshire. And I'm actually here speaking for myself and some of the companies that I'm a partner in.
Thank you.
Representative Grota?
Thank you. Mr. Clegg, this bill doesn't require PLAs. It just leaves that up to the bidding process. So I'm not sure. Your position is that they shouldn't be prohibited, but they aren't.
I believe this bill will entice people to prohibit them in order to take the lowest bid. It's typical when you get federal money. Massachusetts is a good example. When the federal money rolls in and you bid on work in Massachusetts, there's basically what I would call a PLA. Everybody has to pay. Some people know it as Bacon-Davis Act. New Hampshire contractors are allowed to go into Mass, but you have to pay the going rate and you have to treat your people the same. I honestly believe that the intent of this bill is to ice out anybody who, or keep out anybody who has decent wages, whether they're union or non-union. If I'm going to go in and bid against people who are allowed to have an entire force of subcontractors with no workers' comp, no insurances, I'm not going to bother bidding. So I think that what happens when you put something like this out there, you say to people, don't bother to bid here, go to work in Mass or someplace else. We'll take the cheap labor. It's a problem because I believe the quality of the work goes down when you say you don't have to be a quality contractor.
Representative Schmidt?
Thank you, Madam Chair. Morning, Bob. The statement was made in response to a question that I asked of an earlier individual who referenced the fact that this type of legislation is in effect in about 20 other states. And I said, do they have any experience with the bills? Or is it in these agreements in play, these legislation bills, are they in effect in other states so that we can say with some degree of certitude that the bill works, the legislation works? And he said that they don't have any, he was not aware of any of them having any problems. Do you have any experience with other states that have this type of legislation in place?
Every state I've done work for has basically what I would call PLA requirements. You can't bid on a project with them without following certain criteria. And you might as well say it's almost like being part of the union, but you know before you go in what the criteria is. So instead of waiting for somebody to come in and he says, well, you didn't tell me I had to have liability insurance on everybody, or you didn't tell me I had to have workers' comp, whether they're subcontractors. At that point, it's too late. You're already the low bidder, and if you've got the job, who's responsible for that? In some cases, it's the state who's had to pick up the difference. So I don't know about other states. I only know the New England states. I think we still call New York a New England state, but I've worked in Hartford, Connecticut. I've worked in New York City. Having a PLA of some sort, and I'm not saying a union PLA, having a PLA to work off of makes it so much easier to be competitive.
Thank you.
Thank you very much.
Thank you.
Okay. I'm just going to ask for Paul because I'm not sure what this last name says. That's okay. Thank you. We'll pass them out. Started.
If it's one of those names, can you spell it for us?
Well, I'm a Frenchman, so I'll spell my last name. It's Grenier. Dear Madam Chair, members of the House Executive Departments and Administration Committee, my name is Paul Grenier, and I reside at 492 Champlain Street in Berlin. I'm a lifelong resident of Berlin and currently am serving my 7th term as mayor of the city of Berlin.
Valley.
I also serve as a Coos County Commissioner representing Berlin, Shelburne, Randolph. I am here to present testimony to strongly urge you to oppose Senate Bill 274, the bill that would essentially allow out-of-state workers to overtake any publicly funded capital improvement project in our state.
Mr. Grenier,
Yes.
if I may interrupt you for a moment.
Sure.
If you could please just kind of highlight what your written testimony is instead of actually just reading it to us.
Okay.
Thank you.
Sure. All right, let me go to the back page and I'll read the last 2 paragraphs. My personal experience of PLAs provide me with a stark reminder of the value of keeping our locals working. Over 12 years ago, when Walmart came to Gorham to erect their superstore there, the contractor brought laborers not only from out of state but from out of country. There were some arrests for being in the country illegally, while not one single laborer from the Berlin-Gorham area was hired to do the work. 3 years later, Bell Heary, a non-PLA contractor, was awarded the contract to build FCI Berlin. Though Bell Heary did hire many locals, most of the workforce was from outside Coos County. They provided work for many, but did not offer young people a chance to learn a trade. The following year, Babcock and Wilcox, with a PLA signed with the developer of Burgess Biopower, built the 75 megawatt power plant. The vast majority of the labor force was from Coos County, and as part of a structured agreement between K Street Capital and myself with the city of Berlin, the different building trades all started apprenticeship programs. Many of the 18 and 25-year-olds with little construction backgrounds but a motivated willingness to learn a lifelong skill were hired by the union halls. It is a success story for these young productive adults, a chance that they more likely would not have been given if not for the New Hampshire Building Trades Crafts. Senate Bill 274 was written without consulting federal government agencies that hold the power to assist New Hampshire's efforts to repair roads and bridges. It was written without consideration for its potential impact on towns and cities' affordable housing and infrastructure project, and was clearly written as a solution in search of a problem, as New Hampshire has never in its entire history had a project labor agreement on state-funded construction projects. On behalf of Berlin and the North Country, I ask you to please kill SB 274, a short-sighted bill that would impede our state's ability to receive millions of dollars in federal infrastructure funds, and if passed, will only fill the pockets of a few big-shot contractors at the expense of our great New Hampshire skilled craftsmen and women. I'd be glad to take any questions.
Thank you, Mayor. Are there any questions? Representative Marsh?
Yes, thank you, Madam Chair, and thank you, Mayor, for coming all the way down here to see us. It's quite a long trip, and I'm glad to see you in person. Your next to last paragraph there about the federal agencies, are you essentially answering my question to Senator Bradley as to whether this bill would make it impossible for the New Hampshire to access the competitive grants to the Department of Transportation?
I think the way the bill is written, the language is so nebulous that we're going to be feeding lawyers and not paying contractors. It makes zero sense to me.
Thank you.
You know, we're trying to fix a problem that doesn't exist.
Representative Goley?
Thank you, Madam Chair. Thank you for taking the question. In hearing your testimony on the last few paragraphs, is it my understanding in your experience, we heard earlier testimony that this bill before us would protect New Hampshire workers and companies. It sounds to me like a PLA protected the North Country workers and companies. Is that not correct?
Well, I don't want to wade in the waters of speculation. All I can talk about is my experience. When Babcock and Wilcox came to Berlin, I sat down with Babcock and Wilcox and then Joe Casey from the New Hampshire Building Trades Council, and we worked out an agreement where the building trades would hire a bunch of young Berlin Gorham residents to learn trades. And there were approximately 100 new people learning a trade in all of the various trades on that 3-year construction project. Today, most of them people still live in Berlin. They're working jobs that have a livable wage. They're productive members of Berlin. And without that project, they probably would have left. What a crime that would be.
Thank you very much. Are there any further questions? Representative Schuett?
Thank you, Madam Chair. And Mayor, I'm guessing that those young folks are paying taxes to the town of Berlin. Is that correct?
They pay taxes, and I coach a lot of their kids because they've been around long enough. I coach their kids in youth hockey. So it's, you know, life comes full circle. You know what? If we don't take care of our young people and we don't try to keep our young kids working, you plant corn, you get corn, correct?
Thank you very much.
Thank you.
Mr. Delore?
Morning, Madam Chair, Committee. My name is Paul DeLaurie. I live in Bow, New Hampshire, and I am Vice President of Hampshire Fire Protection Company. We're headquartered in Londonderry, New Hampshire, and I am here in support of SB 274. We have regional offices in Swansea, New Hampshire, and in West Lebanon, New Hampshire. And our company employs approximately 175 New Hampshire residents, and we are a proud merit shop company. Our primary business is to install water-based fire protection systems in commercial, industrial buildings, hospitals, schools, large apartment buildings. Our company self-performs design, fabrication, and installation of the fire sprinkler systems by skilled tradesmen known as sprinkler fitters. That is our classification. Our company also provides fire alarm, kitchen hood, and handheld extinguishers. We might be considered the destination employer for our trade. We provide fire sprinkler services and fire alarm construction for most of the work that's private and public in the state of New Hampshire. We are the, say, the big fish in the small pond. We regularly furnish and install systems at the University of New Hampshire, Plymouth State University, Keene State, government buildings. We're currently installing a system at the government Dams Bureau off of Silk Farm Road. We're doing work at Army Aviation. Our company is opposed to project labor agreements, as those work rules and the methods of delivering those construction services are not conducive to our company's ways and means of producing our work. When there are project labor agreements, you've essentially mandated that my company will be not afforded the opportunity to bid on the project. Our 175 employees, and let's say their 2 dependents, would make up 525 people that would be affected by not having the opportunity to even bid on a job based on a project labor agreement. We've had experience with project labor agreement opposition in the past. There was a job corps center that was federal in Manchester years ago. Fortunately, the project did not go with a PLA. Had it gone with a PLA at the time, we would not have participated. The project ended up getting built without a PLA, and my company was successful bidder to design, furnish, and install the fire protection system. So if PLAs are to be put forward in a meaningful way, Hampshire Fire Protection will not participate, and the state would not be afforded our quality work.
Thank you very much. Representative, sir, I know. Representative Grota?
Thank you. So my impression from listening to testimony this morning is that small businesses in New Hampshire don't favor PLAs. And I wanted to ask you why you would not bid on a project with a PLA.
Well, as a merit shop contractor, we are determining our employee relationship, and it's subject to that say agreement that we have as a private employer who's not subjected or beholden to a union hall. And in those work rules, our employees choose to work for our company based on our merit shop philosophy. It's not a question of whether or not one is better than the other. It is their choice. We provide great benefits, wages, 401k, holidays, company vehicles. Our skilled tradesmen are professional people, and all of the supporting people who provide design, fabrication, accounting, all of those people are going to be denied work opportunities directly or indirectly on project to labor agreement type projects, because those work rules and affiliations are not in sync with our merit shop philosophy.
Thank you.
Representative Fellows?
So I'm not expert in this, but I'm trying to understand why you think you wouldn't be able to participate. Because, you know, if you have good benefits, and do you use subcontractors?
We self-employ all of our labor. They're genuine employees of our company. They're not from a union hall. They are direct employees of Hampshire Fire Protection. And we are a merit shop company. We are not a union shop company. And therefore a PLA with labor affiliations that would cause us to have to become essentially union is a non-starter for us.
Follow up. Follow up. So maybe I don't understand, but what I had been hearing is that these agreements don't make you, or don't require, at least in some cases, to hire union employees. They have provisions that say like you have to pay the prevailing wage, you know, and you can't use, you can't use subcontractors, people who are really just employees, but some people call them subcontractors, so they don't have to do the workers' comp and don't have to give them benefits. So I'm not entirely. Are you sure that you would be excluded from being a subcontract? I mean, you're not going to bid on these projects anyway. These are big construction.
Representative, please don't debate the witness. Just ask your question and let him answer it.
I'm trying to, because my understanding is that this is not for just like a retrofit that you might be doing for a building, but that these are big construction projects and your company would be a subcontractor.
We are a specialty contractor, and we do work with prime contractors or construction managers who would execute that prime contract, say with the owner or the state. Our employees are truly our employees with full benefits. We pay all of our workers' comp. We apply all the requirements for proper classification of employees and wages. It's not to be that we are less than, it's that the project labor agreements are such that the rules and the necessity to adhere to union labor type rules aren't ones that we in the merit shop community adhere to. And if there's a PLA, those rules would be in effect, and that's incongruous with who we are as merit shop contractors.
Representative.
Can you just decide, just define merit shop, because I don't know what that means.
Merit shop is essentially, as the name would be defined by Webster's, that pay and advancement is defined based on one's skills and aptitude, and it is not subject to time in grade or some type of seniority. If you're good at your work, you perform at a level that is exceptional, then you get rewarded with pay and advancement based on that merit.
Representative Goley.
Thank you, Madam Chair. Thank you for taking the question. I just want to be sure that I understand that and from what I've heard in testimony, New Hampshire has never had a contract that required a PLA, that if there was a PLA, your choice to not bid on the contract is your choice. That it doesn't preclude you from bidding on the contract just because it is a PLA. It's your choice not to bid. Is that correct?
That's correct. We would choose not to bid on a PLA project based on the union work rules that would be in effect. And in so doing, there's a special carve out for that type of labor versus, say, 90% of construction work that is merit shop. I will be denied, or my employees and their dependents will be denied opportunity if a PLA is mandated.
Representative Fontenot.
Thank you, Madam Chair. So just to confirm, if this bill didn't pass and a PLA were instituted on a job, you're saying your firm would be denied the right to bid?
It's not my right to bid. It is my choice.
Okay.
Because
I just want
I
to confirm,
can't. I will not be subjected to the union project labor arrangements or rules that are in effect based on the PLA. These are onerous rules that I am not going to be adhering to, and I don't adhere to them in the private sector currently.
Thank you.
Follow up. I just wanted to confirm because I keep hearing precluded from bidding, denied bidding, and I'm just trying to find out if that's the case. You won't be allowed to bid.
I believe that the witness has answered that question, I think, three times. Thank you very much. Are there any further questions? Representative Sitek?
I have not seen a PLA. Are you how involved is it? It sounds like you're deputized to be in the union or have to follow all of their rules. Is it that extensive? It would appear that you've got to do reasonable things, follow OSHA, follow workman's compensation, wages are specified. But beyond that, do all the work rules come with this? Is that your objection? I don't quite see why it's so burdensome for you.
We abide by all the rules already. So the PLA isn't going to cause us to do something that we're not already doing already. Besides the union requirements that the finer points of the language in the agreement would pertain to. And it would have us have to be beholden to other decision makers who are providing those work rules that are union-driven work rules. And we are a merit shop company, and we are not going to be subjected to those union-type rules.
Thank you very much. Representative O'Brien?
Thank you, Madam Chair. I will be brief. Thank you, sir, for taking my question. It sounds like you're a good businessman and you have a very successful business. I am aware of it. But if this bill gets defeated, you still would have a very successful business, would you not?
It's likely I will continue to be successful. I don't like the notion of a special carve-out and denying my company and my employees opportunity. You know, if I'm doing business now, I would like the opportunity to do business on the next big project that's involved with the state and not have it be that we're going to have to pass because of a PLA. You've essentially tied my hands when it becomes a PLA. And even if I am, say, a dominant fire sprinkler company, the state's not going to have the benefit of my bid or my work.
Thank you
We'll
very
leave
much.
that. Thank you.
Thank you very much. Thank you, sir. Mr. Casey?
Good morning. Thank you, Madam Chair, members of the committee. My name is Joe Casey. I am international representative for the IBEW, and I was the past president of the New Hampshire Building and Construction Trades, and involved with the federal project labor agreement that was spoken of earlier on the Job Corps Center on behalf of the building trades. I represented them, and I would like to, if I could, base my testimony just on that issue, and then if you have any questions, I'll take them. So, indeed, the Federal Department of Labor put forward a mandated project labor agreement on the of the building construction of the Job Corps Center and the Hampshire Job Corps Center in Manchester, New Hampshire, back in 2005. contractors in New Hampshire challenged that project labor agreement, and the project was delayed and went into arbitration, and all kinds of issues that transpired. This was a period of time in the state of New Hampshire where we had, quite a bit of construction. At the time, we had about 30,000 construction workers. The construction industry was growing, and we were looking forward to proving that a project labor agreement on a government construction job would be beneficial to the state and to the workforce here in the state of New Hampshire. We had already had a series of New Hampshire state procurement bills that were put forward here in the state of New Hampshire to try to address a lot of the concerns that was spoken about earlier. And Senator Clegg was on that committee, and opposed to the building trades and where we were on a lot of these issues. It was during those hearings that a lot of this information came out about how construction workers were being treated on job sites all throughout the state of New Hampshire. Now, obviously, we have a lot of great contractors that are non-union in the state of New Hampshire. We have a lot of great contractors that are union. But we also have a lot that take advantage of their workforce. And that was the basis of the project labor agreement that we were working on to try to prove that it would have been a benefit for the worker in the state of New Hampshire, where workers would have had representation. They would have made the wages for their craft that they were supposed to make, and all of that. And after the challenge went through, they took away the project labor agreement. Job was rebid. Contractor got the job, and it was essentially a 100% non-union project that was taking place. Because of the fact that we lost the project labor agreement when we were trying to make a point and show how the young worker in the state of New Hampshire was not becoming interested in the industry anymore. We followed the project by the Freedom of Information Act in pulling the payroll from the job so that we can make sure that although the job was not under a project labor agreement, all of the employers were still subject to have to pay the Davis-Bacon rates because it was a federally funded project. And the first couple of months they did. And then about the third month, we noticed that some of the trades, most significantly the trades that were working on the civil portion of the project, were now making about $5, $6 an hour less than what they were making the previous month. I contacted the Department of Labor, the U.S. Department of Labor, and asked what the deal was with that. And the winning contractor for the project had solicited the Department of Labor for a new Davis-Bacon rate, which was significantly less. The job was bid under building. Our contractors bid it under building, and they changed it to the heavy category, which allowed the employer to now cut wages, in some cases, up to $6 an hour. So this was in 2009. By the time the project got started, the world in construction had fallen apart at that point. We were down about 12,000 workers in the state of New Hampshire because of the crisis in the economy. And these people just basically didn't have any other place to go. And that's exactly what this project labor agreement was supposed to stop and prove. And we were vindicated by that decision. I and the building trades, we appealed the decision by the Department of Labor, and well after the project was complete, the Department of Labor said that they did err in making that decision, and they should never have allowed that to happen. So there is the poster child project that is cited as far as why we should not have project labor agreements and what have you here in the state of New Hampshire. And the very project turned out to be a disgrace for the worker. Now, these are the young workers, right, who are dads and grandfathers that we expect to send their kids and their grandchildren into the trades, and we now wonder why we can't find any help throughout the state from the workforce, and why nobody wants to come into the trades. It's the last place you're going to see people like that sending their kids, including me. And I'll tell you, we're in a real world of hurt as far as trying to bring in young kids, young workers, or those that have worked in the trade. Half of the construction workers that are worth anything in the state of New Hampshire right now, and we're wondering where they are and why they're not working on New Hampshire projects, are crossing the border and working in Massachusetts. They didn't have that opportunity before. They do now. Now, project labor agreement's not going to solve all our problems, but there's a reason why we have lost a lot of workers, and we continue to do so. And if we really want to start looking at how we're going to increase, the young kids and want them to come into the trades, these are some of the tools that we can use if we choose to do so. If not, we don't have to. It's just a tool. Taking it off the table and just, carte blanche, no municipality, anybody that has state funding on a project will not be able to do so. It's ridiculous, considering the fact that I can't see it happening. It has never happened, and it probably won't. But if a municipality certainly wanted to use that tool to put some people in their high school to work on a project, if any shape or form, any workforce agreement in any shape or form would now be illegal. And that's exactly how this is worded, and it's wrong. And that concludes my testimony. Thank you.
Thank you. But this hearing has run into two other bills, which I am going to reschedule for the afternoon, so we will finish up the hearing here and then go to lunch and do the other two bills of the afternoon. And I apologize to all of you for having this for scheduling this so ineptly.
That'll specifically be 333 and 225.
Right. We will schedule. I'll step out in the hallway.
It'll be directly after.
Mr. Chair.
Yes, sir. Representative Judy.
Yes, thank you, Chair. Mr. Casey, I'm really sorry. I missed a part of your testimony. You are for the bill or you are against the bill?
I'm sorry I didn't say it to begin with. I am opposed to the bill.
You oppose the bill. All right, thank you.
Anyone else? Seeing none, thank you, sir. The chair calls Josh Reap from ABC. Is he not here? Oh, he is here. Okay.
Of course, yeah. Yeah, and I want to be sensitive to people's time, and thank you for letting me speak today. In lieu of my written testimony, which is being passed out, I just wanted to hit on a couple points that are in my written testimony because I think they're germane and relate a lot to the questions and conversations been happening. So I'll stick mostly to that. My name for the record is Joshua Reap. I'm from Manchester, New Hampshire, but I represent Associated Builders and Contractors, which is based in Concord. We represent over 260 merit shop or open shop contractors here in New Hampshire and a few in Vermont. But ultimately, our contractors do bid private and public work every day, and they provide a lot of good quality construction you see even here in this building and next door in the Capitol and across the entire campus here throughout Concord. Ultimately for us, project labor agreements should be left up to the contractor because it's one of those work rule tools that are utilized by contractors if they choose to. There's a lot of confusion earlier about what the state requires. You don't need a PLA to guarantee workers' comp if someone is a citizen, if someone's got insurance and bonding. All that's established by state law already. So if there's a general contractor around here that chooses someone as a roofer for their sub as a roofer that is employing illegal workers, I question that general contractor's work ethic. But in general, our contractors don't do that. They are pre-vetted by the state. They are high quality, high performing contractors. And for us, just in general, I'd like to point out the fact that we're having this conversation today, and it's very passionate on both sides, shows you that this legislation is very necessary. Because there's a lot of talk out of the Beltway and politics in DC about implementing mandates in a variety of parts of life, including in construction with a PLA mandate. Now, again, if a contractor chooses to use a PLA, that works well for them. But let me tell you the problems when you have a government mandated PLA and why we need this bill to prevent them from ever happening. They're effectively a one-size-fits-all. And when a general contractor is told by the state, you have to abide by this PLA and all your subs have to abide by all the work rules in there too, it throws out any kind of collective bargaining agreement those subs had or any relationship they had with their employees. And that's the problem when the government mandates a PLA. It also removes certain efficiencies that a contractor may have with their workforce. A guy here from this Hampshire Fire talked about his merit workforce. He directly employs his individuals and they work out what the work rules look like in processes. When you jumble in a PLA from the government says, here's one size fits all, you need to work within that scope. They go, what the hell, I can't work with that because we aren't familiar with those work rules. It may work for some contractors, but not for us. It removes pathways into construction. Now, sure, a PLA can include them, but it limits which ones they are. Under a project labor agreement, an open shop contractor with an apprentice program can't use their apprentices on the project. It eliminates that pathway into the careers in construction. Because what happens is the PLA says you have to use an apprentice program recognized by the local union hall. That's fine for a union contractor because that's where they borrow their labor from. But for a merit shop or open shop contractor, when you're told you can't use your apprentices on a project or you can't use your apprentice program on the project, what's the point of even having one anymore? Because that closes the door of opportunity for craft workers in the state. There's also something I want to mention too, the benefits, right? There's a question earlier to someone about one of the challenges of why you wouldn't want to bid a government mandated PLA project. It's very simple. Under a project labor agreement, when it's mandated by the government, it says where the benefits go. The benefits have to go through the union hall. Now, if I'm an open shop or non-union contractor and I bid on a job, the government says I have to use a CBA or a collective bargaining agreement under a PLA, all that benefit package goes through the union hall. My worker is not going to be on that job long enough to meet the investment requirements of that union's program. So what happens as an open shop contractor, I'm paying double benefits. I'm paying to a union hall for the privilege of working on this public work project, and I'm paying my worker separately for their 401k, their health care, and their apprentice fund separately because that's what a good employer would do. That's an example of some of the increased costs that come when you have a government mandated PLA. And ultimately, at the end of the day, this bill is about just making sure that as New Hampshire, as government, we don't start putting in requirements that aren't necessary. There's some talk earlier about some of the investment recovery funds that are coming from the federal government. So let's say a state agency applies for it. In that grant language, it talks about having local labor, local hire, and local project labor agreement discussions with local labor. You could still do all that under this bill. The very last portion talks about exemptions. All it says is if you still want to do a PLA, you got to have a public hearing. If you're going to talk about a PLA, which amends state contract laws in a completely different way and foreign to New Hampshire, you got to at least have conversations. So situations like this, like you have today, you have the diverse opinions that come into factoring whether or not that works for the local workforce and the local contractors. That's ultimately what that's about on the end of it, the exemptions on that. And one of the other points I want to make on the bill, the reason why there were some references to those RSAs is because we want to make sure that if a municipality goes to the state and says, we want this carve out, please give it to us, there's not going to be some state agency bad actor who's going to say, well, you got to do it my way. You got to do it with a PLA or without a PLA. It's your choice, by the way, because that's ultimately what the rest of the bill says on here. So the bill, as it says, is it merits now. If the state is a direct contract holder on this, that project won't have a mandated PLA. But if a municipality or someone else wants to get an exemption for something, it's just saying the state won't mandate that they have a PLA on it. So I know that we've been here for a while, and I'm happy to answer any other questions. I hope I clarified some that may already be out there.
Nice job. Thank you very much.
Sure.
Representative Lekis?
Thank you. It appears there weren't enough copies of your written testimony to go around, so
Sure.
if possible, please email it to the committee.
Absolutely. I'll do that by end of day. Thank you.
Thank you.
Seeing no further questions, thank you very much.
Thank you.
Before I call the next witness to testify, I would ask that please keep your testimony to information that the committee has not already heard from a prior witness. If you believe that you're going to just kind of regurgitate the same thing we've already heard, if you could just please wave off, that would be fantastic. Mr. Gilbert?
Thank you, Madam Chair and members of the committee. I appreciate the opportunity to speak with you today. My name is John Gilbert. I'm the president of Martineau Electric. We're an electrical contractor in Dover. We have 25 employees, and the company is 100% employee-owned through an employee stock ownership plan. Briefly, we employ local people. We pay competitive wages. We offer excellent benefits, and we train our people thoroughly and carefully, and we have a very strong focus on safety. Mandated PLAs would introduce a number of unknowns into our efforts to provide efficient and effective results for our customers. It would force us to introduce inequities into our compensation programs and our management program internally by bringing in union workers that are paid and managed differently than our employees, inducing harmful stresses within the organization. In addition, outside workers that we have not developed, trained, and worked with would be a wild card for us with respect to quality, productivity, and possibly safety. We simply would not know them the way that we know our own people. Our costs would therefore be higher to hedge against uncertainty, which is inefficient for the customer. This uncertainty, I would note, adds substantially to the considerable uncertainty we already face with the availability and costs of construction materials. Our people care very deeply about the quality of their work, the customers, the company, and they have chosen to work in a merit-based model because of their desire to do great work as efficiently as possible. We believe that PLAs are not aligned with that model. We are confident that the business leaders and owners in our industry are in the best position to decide the right model for their businesses without government involvement influencing labor management practices. We respectfully request that you support SB 274 to preserve our business's ability to operate in the most efficient and effective manner in the interests of our customers. Thank you.
Thank you very much. Are there any questions? Representative Goley?
Thank you, Madam Chair. Thank you for taking the question. Has the way the current law is written now prevented you from bidding on any contracts?
As
Currently.
This law is not in place. So in the absence of this law, no, we have not been prevented from bidding on contracts.
Would this law prevent you from bidding
Follow
on
up?
any contracts? Follow up.
Yes, we would be disinclined for the very reasons that you heard from the gentleman from the sprinkler company. It'd be the same issue. We have established internal management practices and procedures. We would be required to bring some in that do not comport with the ones that we have chosen to use. And that would be a factor in deciding whether we were going to bid on the project or not.
One last follow-up. So that decision on whether or not you bid on the contract isn't because it's a PLA, it's a business decision on your behalf, correct?
It's a business decision made because it's a PLA.
Thank you very much.
Thank you.
Mr. Bartlett?
Thank you, Madam Chairman. Members of the committee, I will keep my comments short. My name is Rodney Bartlett. I'm the Director of Business Development for Methuen Construction. They're headquartered out of Plastow, New Hampshire. We've been in business over 50 years. We employ between 200 and 300 employees annually. We are a merit-based shop. And you go onto our website, you'll be very clear to notice is a team effort. The entire company works together as a team. We go on a job site, each crew is a team. And I'm going to use one quick example as to how that differs from other organizations. And I'm going to use the example of a steel reinforced concrete retaining wall. We go on site, the team crew chief has his members. They form the footing, pour the concrete, tie the rebar, put the reinforcing panels in place, pour the concrete, strip the wall, and begin the backfill process. They do that as a team together, the same crew. Under other scenarios, you would look at the carpenters union to come in to form the footing, the steel workers to do the rebar and the reinforcing, the labor crew to help pour the concrete, the carpenters to put pieces in place, pour the concrete with the concrete laborers, carpenters come back to strip that, and then another crew comes in to do the earthwork. Essentially the same product at the end, but clearly you can see that the effectiveness and efficiency is going to be less. So our model, our merit-based model, working truly as a team throughout the company, is what we believe makes us different and has kept us a successful company for over 50 years. Thank you.
Representative Fellows?
Thank you. I understand the steps that you just went through. It sounds a lot like putting in the foundation for a house.
Mm-hmm.
So do you have a lot of jobs that are on big projects, like $30 million projects, or do you do more like residential kinds of things?
Most of our projects are in excess of $10 million. We're presently working with Manchester Waterworks on their new well and treatment system in Hooksett, which was nearly $40 million. We are in the process of completing the renovations and expansion of the Merrimack wastewater treatment plant. We have a project at Portsmouth Naval Shipyard that's in excess of $60 million. So we do large projects.
Follow up?
So are you the contractor that bid on this, or are you a subcontractor?
We are the contractor.
Okay, thanks.
Thank you very much.
And thank you for no questions.
Mr. Delgado?
Good morning, Madam Chair and committee. I am opposed to Bill 274. My name is Leonard Delgato, and I'm with the International Union of Operating Engineers, Local 98. You did say regurgitate. You don't want to have anybody regurgitate the same thing over and over. And I'm going to step off into a little different area myself and share some of the behind-the-scenes nuts and bolts, if I may. Our men and women operate the heavy equipment that you see as you drive around on projects, bulldozers, cranes, excavators, and that such. We have a school that we train these young men and women in an apprenticeship that lasts 3 years. Every year we open it up to the public, and we get high school kids and young adults that don't know where their future is going to be. And we take them in and train them. It starts off with classes and then moves out to our 40-acre sandbox to utilize all this equipment that we have to train them on efficiently. The manufacturers are updating this equipment with all electronic computers. And this must also be taught to them so they can use it efficiently. Also in our classroom, there's the OSHA rules and regulations, which are there for safety, for our fellow workers, for all the other trades, and on public streets where you drive by us to secure safety for everyone. Part of our apprenticeship, as their skill gets better, they are allowed to go out on jobs when they are proficient in a or that piece of equipment and are under the tutelage of a senior operator to learn the do's and the don'ts in heavy construction. I'd like to allow questions if anybody has any, and thank you for your time today.
Mr. Spesserhill? I'm sorry?
David?
Yes.
Yeah. I was going to say some stuff, but it's already been pretty much stated.
Oh.
I don't want to waste any more.
Thank you very much. Mr. Chassie?
Good morning, Madam Chair and committee. I'll be very brief. My name is Stephen Chasey. I'm the president and owner of SL Chasey Steel in Hudson, New Hampshire. We employ 175 people in New Hampshire. We're much like Hampshire Fire Protection. We're a subcontractor on a job. All our employees are our own employees. I started the company when I was 23 with one person, myself. I've hired everybody. We've trained everybody. We have certified welders. We're a certified steel company. Very, very highly experienced people. I have an agreement with my employees, my labor agreement. We're a big family. To add a project labor agreement to a project that we're bidding on is not needed for a company like ours or most of the other 90% of the companies in New Hampshire. Most companies are family companies, very highly skilled generations and generations of families. To add something like this to my company would not work, as it wouldn't work with, like I said, 90% of the other non-union contractors. We pay workman's comp. We don't hire subcontractors. All my employees are legal. You know, as like most of the other companies in New Hampshire. But I disagree with this bill strongly. And that's pretty much it. Thank you.
Thank you very much. Representative Schmidt?
So, Mr.
Mr.
Chasey,
Chasey, are you willing to answer a question?
So I didn't quite hear your final statement. So you say
I disagree with the bill.
You disagree? You don't want this bill?
I'm sorry. No,
He opposes the bill,
oppose
Representative.
the bill, yes.
Okay, thank you.
Thank you.
Mr. Johnson? Mr. Brackett?
Thank you, Madam Chair, members of the committee. For the record, my name is Glenn Brackett. I'm the president of the New Hampshire AFL-CIO. We represent 55 unions and over almost 100,000 working families here in New Hampshire. Coming here today to weigh in against SB 274. And as Mr. Delgado said, I'm not going to waste any more time. A couple of things I wanted to clarify from previous statement. Number one, it is a violation of federal law for any company to be excluded from a project labor agreement. Union, non-union, whatever. It's a violation of the law. If an employer chooses not to participate, that's their choice. It's not, the law says they can choose. The reason we've never had a project labor agreement state funded here in New Hampshire is because we are never the low bid. We come in, we bid the job, wages, benefits, and working conditions. the independent, the so-called merit shops come in, they don't pay the same thing that we do, and what ends up happening is that we're not low bid. Now, why are we trying to pass a bill that would say, even if you get the job with low bid, you can't have it? Because that's what this legislation says. So that's the one thing I wanted to clear up. Number two, competition. Due to the fact that everyone is entitled to compete for these jobs, when someone tells you 90% of the companies in this state can't participate, they're not being accurate. Every company in this state can participate in a project labor agreement. If they choose not to, well, hey, I don't shop at Walmart. Should we have a bill that no one can shop at Walmart? It's unfair. What I did pass to the clerk was a copy of the transportation, the requirements from the Department of Transportation for federal money. It's 75 pages long, so please excuse me for not killing 10,000 trees.
Thank you.
Couple of things we have to look at. No one that was questioned today could give an answer to what happens with federal money in this, with this bill going through. I'm different. I called the Department of Labor. I spoke to the Commerce Department, I spoke to the Transportation Department, and I spoke to the White House. And I will tell you this, if this bill passes, SB 274 becomes law in this state, federal money is in risk coming into this state. The mayor of Manchester has written a letter that she's looking at $80 million coming in. Of the $80 million coming in, there's a percentage of that money which is cost sharing or a match by the state government. So Manchester's looking at an $80 million infrastructure project, and this bill has every ability to sideline that. This is a bill that isn't necessary. If we had an issue where we've always been doing this and it was unfair, that would make sense. We have never done it. Why are we doing this? If it's about competition, competition's there, it's the law. If it's about fairness, fairness is there, it's the law. Changing this law to suit the needs of some people that have a political or ideological agenda that they don't want to get involved in project or labor agreements, that is strictly 100% their choice, not mine. So that is the extent of my testimony, and I'd be more than willing to take some questions.
Representative Lekis?
Thank you. Maybe you can clarify something I don't understand, and that is, I think the law, the bill explicitly says that you can't require PLAs, but also you can't prohibit them. But I thought I heard you say that if this were passed, then even if the people you're involved with were the low bidders, they still could not bid on the project. I don't see how that is correct, given the bill.
If the language says that you can't use state money for a contract with the CBA, if that's what that's what the intent of the bill is.
Follow
up.
CBA?
Contract, I'm sorry, collective bargaining agreement. Union contract.
Follow up. I think the bill, maybe I'm wrong, and you can point out where I am, but I think the bill explicitly says that you can't require a PLA, but also you cannot prohibit a PLA.
I think what my testimony says, Representative, is that the federal government has requirements when they bring infrastructure packages into the state. And again, I'll reference you to the package that I gave the clerk, that specifically that if we're going to have no project labor agreements in New Hampshire, then the ability to get federal funding is in jeopardy.
Follow up.
You recognize for follow-up?
Thank you. Yeah, I mean, I wasn't talking about the federal projects. I was talking about ones funded by the state. And you said that if we're not going to, the bill doesn't say we're not going to have collective bargaining agreements or PLAs. At least that's my understanding. If you can point in the bill where it says that, please do so.
I don't have the bill in front of me, but I would say that I'd stick to my main point that if this legislation does pass, we are not eligible for federal funding.
All right, thank you.
Thank you, Representative. Are there any other questions? Seeing none, thank you very much.
Thank you, Madam Chair.
At this time, has anybody in the audience want to testify that has not signed up to testify? Seeing none, I will close the public hearing for Senate Bill 274.
We will hear Senate Bill 255.
I have a question for you. If that's okay. How do we submit? No, because you asked about submitting. Yeah.
Electronically.
Yeah. Just email it.
Email it to the entire committee. Let's go for the thing.
Nice and easy. All right, thank you very much. I appreciate it.
How are you, sir? Mayor.
Mr. Mayor, how are you? I emailed it. I'm not real good on the computer, but I muddled through it. I get all the copies.
Don't catch your foot on that. You did very well.
Thanks for the email. My reading skills.
Oh, well.
You can look at the, see? We're here.
Yeah.
So if you want to look at the calendar, let me see. Wow. Good afternoon. Are any of the sponsors of Senate Bill 226 here? No. In that case, Representative Schmidt, since you're the closest, if you'd care to introduce it. That's next. 226 at 1 p.m., 225 at 1:30.
Good afternoon, committee. For the record, Peter Schmidt, representing Dover Wards 1 and 2, which is Stratford 19. I'm happy to open Senate Bill 226 FN, establishing a recruitment and retention program for state employment, sponsored by Senator D'Alessandro, who's not yet here, and I'll take no
I'm sorry,
questions.
Representative Fellows, is there a problem? Well, fine. Thank you, Representative Schmidt. We appreciate your introducing it. We will not take any questions, I hope. Ah, yes. Senator D'Alessandro, you're on deck.
Thank you, Madam Chair. Sorry to be late. I was at another hearing.
Turn your mic on, please. Thank
Got
you.
it. Come before you as the prime sponsor of Senate Bill 226 FN, establishing a recruitment and retention policy for the state of New Hampshire. The bill passed the Senate, was amended in the Senate, and currently we have 10,604 total positions that are classified in the state of New Hampshire. We have 1,967 vacancies. That's 18.6%. We have 407 full-time temporary listings. That's up to 6 months. We have 185 vacancies. That's 45.4%. Unclassified full-time, we have 427. We have 69 vacancies. That's 15.5%. Totally, we have 11,428 jobs in the state of New Hampshire. We have 2,221 that are unfilled. That's 19.4%. So the vacancy rate at the state is approximately 20%. I've got a breakdown of all of where these vacancies occur, but clearly we needed to go in a new direction. And recruitment and retention are vital for the state of New Hampshire. Recruiting the best possible people and retaining the best possible people. This bill allows for that process to begin, directed by our DES agency, and that's it. We have a crying need for people. This is one way to try to recruit and retain people. And Admin Services knows how difficult this is. People are here from Admin Services that can comment on this, but when you have this many vacancies for this long a period of time, state government can't function as effectively and efficiently as it has in the past. And that creates problems. I think I've stated this to you before, Madam Chairman, that if we could fill every vacancy at New Hampshire Hospital, we would have no waiting list. Currently, waiting lists exist for both children and adults. So if we could fill these jobs, we wouldn't have vacancies. That would be in the best interest of the public in order to do that. So, with that, I'll address any questions. As I say, people are here from Admin Services who can go over the specifics and can go over the amendment. The amendment to the bill sets a process in place where you go here, you go there to get approval.
Excuse
I
me,
think you might have
Senator,
that.
is that the amendment that you adopted in the Senate?
Yes, it is.
Okay, well
So-
then we don't need to know the details because that is the bill as we have it.
That's correct. Wonderful. Thank you. Thank you for that clarification, Madam Chairman. Couldn't figure it out myself, but it's okay. Thank you.
You don't need to try to confuse us. We do just fine on our own.
Confusion is the byword of the legislature. Mass confusion is even more important. With
Are there
400
any
people.
questions, Representative Sitek?
Senator D'Alessandro, I have an uncomfortable question. Don't you think state government, the departments in state government are striving mightily to do this on their own? What rabbit do you think can be pulled out of the hat? The rabbit, of course, is more money, but that's not quite on the table.
Well, thank you. Thank you very much for the question. I'm sure that each department is working diligently to fill its vacancies. But as you know, the vacancies are there, the vacancies haven't been filled. This is another methodology to put in place to aid the departments in their search for quality individuals, but more important, to retain quality individuals. So it's another little thing in the rabbit's hat. We call it a plus rabbit.
Thank you, Senator.
You're welcome.
Representative Pearson?
Thank you, Madam Chair. Thank you, Senator D'Alessandro, for taking my question. So, aside from looking at a veto-proof majority of senators that are even co-sponsors of this, I'm trying to understand this is not a commission or a committee. So this is sort of a I'm trying to understand just the methodology here that would be employed to come up with this. Because as an example, in this committee, we see the gentleman from personnel, and we have a lot of interaction with JCEC as far as classifications. And we heard testimony earlier in reference to their inability to modify pay grades based on market
Yes.
things that are going on. So with this, I like the idea. Don't get me wrong. I'm just trying to wrap my brain around what this looks like, since it's not a committee or a commission.
Well, thank you for the question. I think Cassie Kane and her Director Lori could be very helpful in giving you a clear and succinct explanation. Sometimes I cloud the issue.
They're
I know.
getting the assignment to do the work, so I think we should ask them what it
Right.
involves.
Right.
Are there any other questions for the senator? Seeing none, thank you very much.
Thank you, very much, Madam Chair. Pleasure to
right.
be here.
Cassie Keen and Lori Rudis.
Cassie Keene. I'm the Deputy Commissioner of the Department of Administrative Services, and I'm here with Lori Rudis, who's the Director of the Division of Personnel for the state of New Hampshire. So, we proposed this legislation and worked with Senator D'Alessandro because, as the data he shared with you reveals, we have been facing significant vacancy rates throughout state government and often in very significant positions. He mentioned, for example, New Hampshire Hospital. Commissioner Hanks is here. Department of Corrections has significant vacancies. Nurses, corrections officers, engineers, child protection workers. And we've been racking our brain over the years of working together about what could we do differently to try and recruit people to these difficult positions. So one of the tools that we do not have in our tool chest today is proposed in this legislation, and it would give the Director of the Division of Personnel authority to establish a program to pay incentives for recruitment and retention. So, so to get to the heart of Representative Pearson's question, how does this work? If you look at the bill up on line 4, it says the department shall obtain the approval of the fiscal committee of the general court prior to developing and implementing the program. So this would be enabling legislation that Director Rudis would then work with her staff and with our commissioner's office to establish the parameters of a paid incentive program for recruitment and retention. And when we settle on what that model looks like, the first thing I think we have to do under this bill is to go to fiscal committee and get their approval. And that is required in line 4 and 5. And that would lay out what would this program look like, and I'll let Lori talk a little bit to that. But I also want to just further answer Representative Pearson's question, because if you go over to page 2, line 1 through 3, it says that any expenditures for recruitment and retention incentives or bonuses pursuant to this paragraph shall require the approval of the fiscal committee for the general court. So the way I see this, this authority structure in here being is that the fiscal committee wants to see the program before it's up and running, and then as any agency decides that it would like to offer a recruitment or retention incentive, that they would have to go to fiscal committee and get that permission before they could actually offer that and of course pay.
Thank you. Representative Rhodes and then Schmidt.
Thank you, Madam Chair. Are you able to specify or give me an example of the vacancies that you're speaking of? Are these full or part-time positions?
Those are full-time positions, not the part-time positions.
Is there more one or the other that appear to be like the most vacancies?
It would be the full-time positions right now. I mean, you have to look at, excuse me, you have to look at seasonal hires. So those ebb and flow based on the season, hiring up for the parks and the beaches versus for the ski mountains and things like that. But predominantly, it's the full-time positions that have the most vacancies.
Yes, thank you. Representative Schmidt.
Thank you, Madam Chair. So I understand at the beginning, you certainly would want fiscal involved. And for the flexibility aspect, fiscal would also be very good on a continuing basis, but are they going to be the only authorizing, or can you put it in the budget to some degree? Just what, so maybe finance would be involved in some respects.
I always envisioned that agencies would request budgeting to support these programs. So I see it as multiple layers of legislative oversight on where is this going and how is it being mobilized, if you will. So no matter what, an agency has to have the money that they could use to pay this. And the first place you do that is in budgeting. And should an agency want to access this kind of program and not have it, then they have to get transfer permission within the budget, and they would do that by going to fiscal committee as well.
Yes.
Thanks.
I noticed that this is repealed as of July 1, 2023, so, which is the start of the next biennium's budget. So I presume you're assuming that whatever you develop in the next year will be implemented as necessary in the next budget, and it won't be this extraordinary program. Is that correct?
Yes, I also think it was another check and balance put in place around the authority, and how is the program established? How is it being operationalized, and do they want to continue? Generally speaking, when I look at this bill, if you go back to the first page and you look at RSA 21I 42 Roman 6, it is both it's a law that gives the director of the Division of Personnel authority and responsibility to take certain actions. And so I view it as enabling legislation.
Okay, thank you. That helps. Representative Bailey?
Thank you, and thank you for taking my question. Are you able to compare your recruitment difficulties with those in the economy at large? I mean, are you worse or better, or?
You want me to take that?
Yes,
Okay.
ma'am.
I would say that we have some challenges when it comes to the market, comparing if we're talking just base salaries that we're looking at. And, but we have excellent benefits, and we're really trying to market those benefits to try to make up for some of that compensation. But I think we need some flexibility. I think we need some tools in our toolbox to compete when it's necessary. And I'll give you an example. We have agencies that might have an engineer, and they're both saying, oh, well, I'll give you this, and I'll give you this, and I'll give you this. And then this person gets this, this, say, the $100,000 that they're getting an offer for, and then they just take it, they go to the outside community, and they're probably getting $140,000 for it. So there's got to be multiple layers of tools that we can use. We would want to focus on making sure that we are looking at the positions that are most difficult to fill. So it wouldn't be like across the board, okay, everybody gets a bonus, everybody gets to do this. We also have a lot of personnel laws where we have to make sure that there's fairness included in whatever program that we're developing. We can't leave it up to somebody to get themselves in trouble saying, I like A and I don't like B, and I'm going to do this for A and not for B. So I think it's important that we just give ourselves all the tools we can, and when we need to compete. We have some departments that are really low on some specific jobs that are critical. I would call them critical positions, and we need to have some tools to be able to retain people as well as recruit.
Thank you.
Does that answer your question?
Yes, thank you.
Thank you very much.
Representative Judy?
Yes, thank you, Madam Chair. Good afternoon, ma'am.
Good
On line 15, can you give me more explanation about the retention incentives, please? And based on what? Line 15, retention incentives.
I think the purpose of this is to make clear that it's not a gift, and trigger RSA 21G ethical obligations. And I'm sorry, I'm not familiar with specific provisions right now, but it's intended to make sure that this payment is outside of those provisions.
Representative Schuett?
Thank you, Madam Chair. Good afternoon, ladies.
Good
I am curious to know the nature of the vacancies. Are you finding that these are just literally long-term, not filled? Or have there been situations where a number of people have been employed but then are dissatisfied with whatever the reason, work or benefits, and left?
Well, I can give you a little bit of information. We are breaking down when somebody leaves state government. One of the things that we're trying to build in now is exit surveys. Why are you leaving? What is the reason? Right now, they currently have, if you're looking at a chart, okay, there's a large section that says personal. Well, personal doesn't tell us anything. So we're working with our financial data management folks to get in there. Is it specifically because of pay? Are you leaving the state? Is it benefits? Is it a bad working environment? Is it a supervisor? So we'll be able to drill down and get you more information in the future.
Follow up.
So do you have any kind of projection as to when this kind of data might be available?
I would say we would probably July, somewhere around July, we would be able to have it up and running, and then it would take each quarter we could come back and be able to deliver that information.
Thank you. Representative Fellows, you had a question?
Thank you, Madam Chair. I know that currently you have some special incentives, they're probably related to COVID, for some positions. Is that correct?
I think they've all
Or
expired.
bonuses? Oh,
I
okay,
think
but
they've
they
all
were,
expired.
so my question is, how did that operate? And are you thinking of modeling this program along the same line as that one? So do you identify you don't identify individuals that they have to go back to fiscal to get approved? I assume it's like some class of employee.
Yeah, I agree. I think what they're looking for us is a program and what maybe potential costs are. Probably fiscal going with it to say, what do you think this would cost? I'm imagining it's something.
Yeah, I also do see us targeting types of positions that are particularly hard to recruit. So I think that might be where you were getting at.
Thank you. Representative Sajak?
I wish I could think of a question. I just want to say good luck.
Thank you.
Representative Pearson?
Thank you, Madam Chair. So this is going to tie into a couple of other things that were said. With the JCEC, right, we classify certain types of jobs that are similar amongst agencies, right, together. Okay, step and grade, government pay. It's everywhere, right? So how you're going to have to, and I don't know if you can answer this now, but you're going to have to figure out a way where you have a very specific one of those step and grade jobs, right? To either move the grade or because what's going to end up, what JCEC was created to do was to level the playing field. And I'm concerned that this will completely untie that knot, in the sense of not specific individuals like Representative Fellows seemed to address, but when we're looking at reclassifications of certain job types, that may be an answer to what you guys come up with. I'm just trying to, Senator D'Alessandro couldn't answer it, but this is not a committee or a commission. Yeah. So when you're talking about a broad spectrum of across the board government, I'm confused, and please help us out here because you mentioned on page 2, line 4, the repeal of this. That seems there's a repeal for this one or I-42-6. This rewrites I don't understand this repeal business. There's no date.
That's what
July 1st, 2020.
Okay. So do you feel you can accomplish this in what amounts to a year?
I do believe that we will get something up and running in the nature of a pilot, and we will have data that will allow the legislature to decide, oh, this was a good idea, it worked. This wasn't enough time to prove the idea or disprove it, or it turns out it wasn't a great idea and we want it to go away. So, pardon?
We're concerned that the timeline is too aggressive.
Well, if you would like to extend it, you're not going to hear any opposition from us.
Okay, thank you.
As you're aware, government moves at the speed of smell, right? So a year in the real world in government is not the same, and that's
Right.
I'm
It would be helpful to us.
I would expect that, if nothing else, this would be any successful parts of this would be included in the budget.
I hope so too.
Yes, they would have to be, yes. And I had a question about the, this obviously is going to affect negotiations with the employees' unions. What are you doing about that, or is that a concern, or what?
So there is a paragraph of this that says it's specifically outside of collective bargaining. I'm looking for the language now. I'm sorry. Oh, it's paragraph D on line 24, beginning on line 24. I actually think that the unions will welcome this legislatively authorized program because I think what we do with a recruitment and retention incentive plan is we mobilize our workforce and ask them to help us. I'll let Lori talk about the best way to recruit people. And it turns out it's all around us, but go ahead.
Sure. I'll just talk about a program that I had in my former position. So it was called, say we were looking at getting highway maintainers, and that was going to be an area that we were going to focus on. What we'd do is we'd have a referral bonus. So that way the employee's getting something after a period of time, and the new employee and the employee that referred them. So those are the type of programs that you would say, okay, I'm going to go out and recruit some of my buddies because I have a little incentive in this myself to earn some bonus money. So I'm going to, be out there talking to people. That word of mouth, and you're already working for the state, is very popular because you can speak to all the benefits and what we have and what the hours may be, and to different opportunities throughout, state government. So that's an example of something that we would use it for.
Okay, thank you. Representative Blackish, you had a question?
Yes, thank you. So, assuming this passes and you end up finding some things that work, for this to continue beyond July of 2023, would it require, in addition to something in the budget, would it require legislation to extend or make permanent some of the things in here?
It would require a change of the date, and I think if this passes, that we will begin working on two fronts. One is we will be working on the design of the program. What would we want to present to fiscal committee for approval? The other thing is we begin working with agencies to educate them about the passage of this law so they could consider the kinds of vacancies that they have and whether and to what extent they might want to propose funding in their budgets for the next biennium.
Follow up?
Follow up.
So if I understand correctly, for anything to continue beyond July 2023, you'll have to come back and ask for some legislative change.
Yes, unless this committee amends the bill.
Well, eventually.
Hint,
Okay.
hint.
Yes.
Thank you.
Thank you.
Good job.
Representative Pearson, you have a follow-up?
I have a question for the chair. I'm just looking at the calendar here, right? So we're going to start working on the legislature will start working on the next budget in the fall of 22. So your timeline of July of 23 is it doesn't really fall in line with the legislative calendar.
It gives us fiscal year 23 to get this up and running and.
Because you're not going to, you're talking, if you were to do that in July, the fall of 23, you're talking about amending an enacted budget.
Right.
So
and
this really could go, this date of July of 23 could be pushed out to December of 23 and have really no substantive effect on what you would recommend in the budget cycle. Because the next budget cycle would be fall of 24.
So the next budget, and forgive me if I get the dates wrong, but the legislature comes back in January of 23, and that's a budget year, and the
Right.
budget is debated from January through June, right?
The filing
So-
period would be the
right.
fall of 22.
Right. So what you are saying that's correct is all agency budgets for next fiscal year are already decided, right? So if an agency, if we have approval from fiscal and an agency wants to seek authority to pay a recruitment or a retention incentive bonus, I think most agencies are going to have to go to fiscal and ask to transfer money as well as permission to pay a bonus for certain positions.
And also, they would include it in their budget going forward for the
Absolutely.
next biennium. Okay.
And they would include it
Yes,
in
it's very tightly
in their
scheduled.
proposed budgets. It's very, very tight. We think it's worth it. We think it's a very important tool in the toolkit.
Okay, thank you. We will continue to be concerned about your performance on the schedule. Any other questions? Representative Schuett? Oh, which of you has a question? Representative Fellows, thank you. I wasn't sure.
Thank you. So when this gets repealed in July of 2023, this goes away, but right now you have the authority for developing a program of recruitment, selection and placement of qualified applicants. Why do you even need this? Why can't you just operate under what's currently on statute?
I personally don't think we have authority to pay incentive bonuses for recruitment or retention purposes, and so that's why we asked for the legislation to be proposed. This authority that you see in existing law, I think it's again a law that establishes the Director of Personnel's responsibilities and authorities, but none of that authority is explicitly empowers her to have a paid recruitment or retention incentive
She needs the
program.
legislation to put money into it instead of just
Yes.
attaboys and certificates,
Yes.
I have the
which are
ability to-
valuable, but not always as useful. You'll follow up.
Yeah, so I thought that you had been doing this. Were you using federal money, and so that's why was different than what you're proposing now?
I'm not sure are you talking about like when the liquor stores got a 10% increase?
No,
She's
I thought,
talking about the COVID and emergency bonuses and
Yeah.
retention program,
Yeah.
which were federal, and they were also limited in time to
emergency.
the emergency.
Yes.
It's not an ongoing program. Exactly.
so wasn't that under this authority to use that money?
No, it was under an executive order.
Okay.
Thank you. Are there other questions? Representative Allegro?
Thank you. So that's an interesting point. You've had a trial period with federal dollars, and has that improved the situation?
I'll speak to it. I'll try to speak to it. Thank you. What I think happened with that was we had people who could have chosen to not work any longer due to COVID, and that we would have had a crisis on our hands if we didn't give some incentives. I would say it was used more as like a hazard pay would be used, saying you're at risk and you're out inside of these environments, and we're going to recognize that risk as we do. We do have hazard pay that happens in other areas. So I think it was more used to that than really understanding how do we recruit and retain people. Thank you.
So this is actually, I think, a question for the chair, and that is sort of understanding what this language does on the repeal. So right now, there's something in 21I-42 Roman 6, and this bill would replace it. And then after July 2023, it looks like it repeals RSA 21I-42-6. Does it revert to the prior language, or does it just go away? That's what I thought.
Thank you, Madam Chair. So this kind of piggies back with my original question and then some of the other questions. And I apologize if this was answered because I'm still trying to figure it out from other questions. Are you able to, what area would you say are you having the most difficulty? Is there like a certain area where you look at your departments and say, this is the department that we just can't keep jobs filled? Thank you, that's what I wanted to ask.
Yeah, we could talk corrections, we could talk nurses, we could talk child support workers.
So
We
law
have highway
enforcement and healthcare.
maintainers. And in other areas.
Child protection workers.
Yeah, child protection workers, we have, you know, engineers, we have it tough. We are, we're getting out competed by the market in technology. So it's,
Highway maintainers. In DAS, we have a series of positions called building service workers. They clean state buildings. We have a 50% vacancy rate in those positions. It's just really, really difficult to recruit people and to retain them.
Thank you. Other questions? Representative Fellows, one question, please.
Thank you, Madam Chair. So it seems to me that most of the problem is probably that we just don't pay enough. You know, we don't have competitive wages. So I'm thinking that, you know, this recruitment and retention bonus thing for just a year or two is not going to solve the problem. And also, I know with the
And your question?
unclassified employees, you use that firm that does an analysis of what the positions and what the pay grade ought to be. When was the last time we did something like that for the classified employees positions?
So I'll ask Lori to help me out a little, but when Representative Pearson was discussing the JCEC and the process that we use with Corn Ferry, our classified positions are part of a classified system, and we do that same sort of comparison of position types across state government for all classified positions in a unit in the Division of Personnel. Okay, so we do look at if I'm coming up dry with an example, but if I do this job in this department and same job in this department and same job in that department, they're similar job functions, and therefore those positions are ranked similarly. Also, we just.
But when did you last do that?
Well, as a matter of fact, we do it okay, I'll let Lori talk. Yeah.
so we're doing this almost daily, right? We have four people. We have four
Yes,
people that,
Representative Fellows, please clarify. Your mic?
When you did it for the unclassified, that you were comparing it not just within state government, you were comparing it to other similar positions outside of our state government, but I distinctly heard you say that you answered me by saying you were comparing positions across the state. I'm asking, when is the last time for classified you made a comparison to, you know, outside of state government or compared to other state governments? And I understand benefits are different, but you can do a calculation that kind of adjusts for that, I assume.
Yes.
And I won't ask another question, as long as they answer my question.
So there's a difference between ranking positions and pay, and we did just do a compensation study, and I'll let Lori speak to how we do the ranking of positions, and then we'll tell you about our compensation study.
I think the question was compensation.
Okay.
yeah, I think Kelsey's going to speak to the fact we did 2 years ago. We received the authority, or we were asked to do a compensation study. We picked 100 positions all across the agencies, all different levels of the agencies. That report is posted on our website now that you could take a look at if you wanted to. But 2 years, a lot of things have changed, right? So we've come into COVID. A lot of things have happened that have made the market a different place than it was 2 years ago. As far as the internal ranking, that's happening every day, and you don't care about that. Okay.
Thank you very much.
Did that answer your question, Representative? 2 years ago?
I'm sure you have a lot of issues with this. Any other questions? All right, thank you very much for the information. Paul Raymond.
Good afternoon. Thank you. Hope you don't mind if Commissioner Hanks joins me to answer any questions that you may have. Good afternoon. My name is Paul Raymond. I'm the Director of Security and Training for the New Hampshire Department of Corrections. And you all know Commissioner Hanks, who's here with me. And we are here testifying in favor of Senate Bill 226. Recruitment and retention is the department's #1 priority. In the last few months, we have streamlined our hiring processes, unveiled a dedicated jobs website, and initiated statewide radio and social media recruiting campaigns. Those initiatives, while helpful, are still competing with organizations like the Federal Bureau of Prisons that is offering an $11,000 sign-on bonus at their Berlin, New Hampshire facility. Locally, even police departments like Pelham, Rochester, Bedford, and Concord are offering sign-on bonuses up to $15,000. Elsewhere in the country, states like Alabama, Florida, South Carolina, Delaware, Iowa, Virginia, and Nebraska have increased pay for corrections officers, and many have added new hire bonuses to their recruitment efforts. Iowa, as an example, increased pay and added hiring bonuses and have seen a 15% increase in qualified applicants. The Department of Corrections currently has a 34% department-wide vacancy rate among its security staff, a 16% vacancy rate among its nurses, and a 50% vacancy rate among mental health clinicians. That equates to poor work-life balance for our team and significant overtime to fill positions to meet our minimum standard for shifts. Corrections work is challenging work, and it's even more challenging to find the right person, not any person, but the right person to work inside the walls of a prison. Allowing the state to offer recruitment and retention incentives, including bonuses and referral fees, is one positive step toward helping our department attract the right people. I respectfully ask that you support Senate Bill 226. Thank you, and we're happy to answer any questions that you may have.
Thank you. Are there any questions? Representative Pearson.
Thank you, Mr. Raymond, and thank you, Commissioner. 34% is pretty staggering. So in the course of your budget, how fast do you expend your overtime line? Your yearly how quick do you use that up?
Representative Pearson, thank you for that question. We expend the budgeted line in approximately 1 quarter in 1 month, and we have a budget we've spent about $3 million a quarter in overtime. We budget about $4 million in that line. There's a budget footnote that allows us to move money from our funded position lines and benefits lines that are the result of vacancies to fund the overtime that's caused from those vacancies. So we use our own internal budgeting lines, but we have a transferring mechanism. Last year, we spent approximately $16 million in overtime. And we're forecasting about the same this year because of the number of retirements we had in December and poor retention efforts going on currently in the work environment.
Yes, thank you. Other questions? All right. Seeing none, thank you very much for the information. Is there anyone else who wishes to testify on Senate Bill 226? All right, seeing none, I will close the hearing. Open the hearing on Senate Bill 225 and call Senator French.
Thank you, Madam Chair. Good afternoon to you and the entire committee. For the record, my name is Harold French. I'm Senator for District 7, and I'm here today to present to you Senate Bill 225. This is a short bill. So this bill will eliminate the need for a New Hampshire licensed auctioneer to carry a $25,000 performance bond. I personally have been a licensed auctioneer in this state since I was 18. I became an auctioneer when I was a senior in high school. I grew up in the industry and it has changed drastically since the 1970s. Until the advent of the internet, 100% of all goods sold at auction were sold live and in person. All were conducted by licensed auctioneers. Today, perhaps 2% of goods sold at auction in New Hampshire are sold live, with the majority being sold on the internet.
This state does not require licensing for those conducting auctions online, as it was determined to be impossible for the state to regulate interstate commerce when dealing with online auctions. Since the start of licensing, auctioneers had the requirement of maintaining a performance bond. There has never been an instance where the bond was used to settle a dispute among the parties. This bill would update our licensing laws, making them more reasonable for the way business is conducted today, and eliminating an unneeded expense and hurdle for those wishing to pursue their business goals of auctioneering. Thank you, Madam Chair.
Thank you, Senator. Are there questions? Representative Pearson.
Thank you, Senator French. Just so I have clarification, you're saying that the bond, the $25,000 bond that an auctioneer has to have, has never been
Pulled.
never been needed, to your knowledge, ever.
To settle a dispute, no, it hasn't. So, okay.
Okay, thank you. That's, yes. Any other questions?
Good.
Thank you very much,
Thank you
Senator.
very much.
Is there anyone else who wishes to testify on Senate Bill 225? All right, seeing none, I'll close the public hearing and open the hearing on Senate Bill 382. That right? Yes, 145, Senate Bill 382. Let's see who's calling. Senate Bill, is Senator Khan here? Yes, I recognize Senator Khan.
Hello, Madam Chair, members of the committee. I'm pleased to offer Senate Bill 382 to you. The bill is a fairly simple and straightforward. Might be having been complicated somewhere along the way. I haven't kept up with your emails. But we've had a temporary licensure requirement in the state during the emergency order. And the emergency order ended at December 31st, 2021. And that temporary order allowed out-of-state physicians to practice in the state of New Hampshire via telehealth. There were there were many licenses involved in that, and you've got the commissioner, the director of professional licensure and certification here. They can answer that question, but I believe the number is somewhere around 22,000 temporary licensures.
Thank you. We've gotten that information on many other occasions.
Okay. Significant is that there are several pieces of legislation attempting to clarify the process of moving from temporary licensure status to permanent or continuing licensure, one of which is Senate Bill 277, and maybe that's one, Madam Chair, that you've already heard, that extends that temporary licensure date. Got it. So the reason why to pass on this bill, one, is we want to provide the same quality assurances for our in-state, for people receiving care from people in-state as they receive out-of-state. This kind of quality control is assured with a licensure provision a person who's licensed out of state will present that license. It's easy to do those kinds of background checks on people. Those quality controls are important for patient safety and health. The second is that that's important for insurance coverage. Insurers are going to be looking for has that kind of quality assurance been verified by our state OPLC. So that's important to make sure that people are getting the reimbursements that they deserve for the care that they're seeking. And finally, we need a transition for those folks that continue to use the temporary licensure route beyond January of 2024 to be able to transition to a permanent licensure, and this provides an easy route. The new section that was added in Section 2 is trying to clarify that the state will seek reciprocity agreements with those that are not in the physician compact. That compact covers 31 states. And so trying to reach to those that might not be in that compact currently. And that's the nature of the bill. And because Director Lindsay Courtney is here, I think remainder of questions probably most efficiently asked of her. But glad to
Thank you,
answer any.
Senator. We'll grill you a little first, I think. I have a question. What is the consultation services referred to in line 7?
That would be where a in-state physician is consulting with an out-of-state physician on a particular type of care or modality of treatment.
So that's a physician-to-physician consultation and not patient-to-physician.
That's correct.
Thank you very much. Are there any other questions? Representative Schmidt.
Thank you, Madam Chair. Good afternoon, Senator. So has it been resolved, established, or by adjudication or whatever? I know the Mayfair decision came down a couple of years ago, whether a service that's provided by telehealth is being performed in the state of the recipient or the state of the provider, or maybe even both. What is the status of the law right at the moment with regard to that issue?
I'm going to let the director answer that because I think you're picking up on the variety, the variations on delivery. If a person is in state, I mean, this is particular to an in-state person seeking care in state, and then there are all sorts of variations off of that.
Right. You probably have received
Follow-up.
Thank you. You probably have seen some of them yourself. I certainly have received a bunch of emails talking about please kill 282 because, 382 because we want the freedom, blah, 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 blah. But the question is, what is the law with regard to?
And there are very many variations. If a person is deployed out of state and has out of state insurance coverage for that, the person's going to seek the care from a person in whatever state that they have their insurance coverage provided for. But again, I'll let that. There are a lot of variations.
I understand your reluctance to
There's just a
opine.
lot of variations on that question.
Other questions for the senator? All right, seeing none, thank you very much.
Thank you.
Director Courtney?
Good afternoon, Lindsay Courtney, Executive Director, OPLC. OPLC is pleased to testify in support of Senate Bill 382. which is really intended to clarify the existing state of the law in New Hampshire, which is that in order to practice in this state and the provision of services is deemed to occur in the state where the patient is located, that you need a license. And I think that is not explicitly clear because it's not set forth in statute, but it's been interpreted, I think, by regulators as well as other states to be that way. And the reason for that is twofold. First, the state obviously has an interest in protecting the people within its state. If a person is in New Hampshire, we have an interest in protecting the person in New Hampshire. We probably don't have the same interest in protecting somebody in, Alabama. But also, our jurisdictionally, right, our jurisdiction only extends to New Hampshire. So when given the choice of, does our jurisdiction extend to where the provider is located, or does it extend to where the patient is located? Public policy probably dictates that the jurisdiction really is governed by where the patient is located, because the purpose of licensing is to protect the public. So throughout the pandemic, obviously, as you know, telehealth essentially exploded overnight, and the platform grew immensely. And we started to field a lot of questions about, do I need a license for this? Do I need a license for that? It's not typically within our practice, based on legal advice from DOJ, to provide such legal advice, right? Do you need a license? We point people to the statute and the rules. And the statute and rules say, well, if you're practicing medicine in New Hampshire, you need a license in New Hampshire. But it doesn't explicitly state what constitutes practice in New Hampshire. And so that's what this is intended to cover. The other issue this addresses is choice of law. The only other association group of associations that I'm aware of that have taken an alternative position to the idea that the provision of services occurs where the patient is located is a couple of the social work or mental health associations nationally have taken the position that that the service occurs where both the provider and the patient is located. That really makes no sense because the laws differ in each state. So, for example, in New Hampshire, the duty to warn may be different than in Massachusetts. So if the provider is in New Hampshire, but the patient is in Massachusetts, which law do they have to follow? There really should only be one that they have to follow, and I would submit that it should be Massachusetts, because that's where the patient is located, and Massachusetts has an interest in protecting that patient. So again, this was intended to clarify the existing state of the law, which has always been that if you're practicing or providing services in New Hampshire to somebody located in New Hampshire, that you need a license. There were concerns, I think, based on confusion in the stakeholder community that that this statute would essentially eliminate the ability to seek providers elsewhere, and that, from my perspective, is not the case. However, based on those concerns, I think what we largely heard was that there was a concern that providers needing licensure could not obtain licensure easily. And so, particularly for physicians. And so Section 2 is intended to address that by allowing the state to enter into reciprocity agreements to streamline that process. We do have a medicine compact, a physician compact, and again, 31 states are participating. I would not say it's the best compact. It's not like the nursing compact or the driver's license compact that you can just go wherever. It does require one to apply to the Federation of State Medical Boards to process their credentials, and right now there's an 8 to 12 week backlog. I will say that this would allow us to enter into separate agreements with states to streamline the process, and additionally, we already have existing ability to issue temporary licenses to people who are pursuing permanent licensure. So there certainly is an opportunity for people to obtain license in a fast time frame. with that, I'd be happy to answer any questions that the committee may have.
My goodness. Representative Allegro, Lacus, Marsh, and Pearson in alphabetical order.
Thank you. I'll ask my question by way of example so that it can lead us to a yes or no answer. Say a patient lives in Massachusetts, their physician's in Massachusetts, they move to New Hampshire. They can't find a suitable or acceptable physician in New Hampshire that does the same thing. Maybe it's a specialist. So they go back to their Massachusetts physician, and indeed that physician even prescribes medication for them, which is delivered to a New Hampshire pharmacy, and insurance covers that prescription. Will that be allowable under this current bill or this law?
The question will depend on where did the patient visit occur. If the person went down to Boston, like I do, I get all my specialist treatment in Boston. Then certainly the provider was practicing medicine in Massachusetts. Massachusetts laws govern. They absolutely can do that. This bill has no impact on that. And they can certainly dispense to a New Hampshire pharmacy.
Follow up. So I'm going to complicate it a little bit and say it's, there was no visit, no subsequent visit, but the patient is on an ongoing prescription. So they haven't visited that physician now in Massachusetts since they changed their residence to New Hampshire. But they need that prescription. The physician supplies the prescription and it's picked up in New Hampshire. Is that allowable?
Yes, because there was no service occurring between the physician and patient. Is based on first of all, there's an exemption in the medical statute in the medicine statute for those types of consultations across border. And then secondly, I would submit that that's not providing a service. It's certainly continuing to authorize prescriptions. But as you know, and I know Representative Marsh knows, that physicians will call you back often for a visit saying, I can't authorize any more prescriptions based on prior examinations without submitting to another examination. So the question would be, at a follow-up service, how does that occur? And I will also say that this issue came up during the pandemic. The reason why we issued 22,000 healthcare licenses was because 15,000 of them were Boston providers who were New Hampshire Medicaid enrolled providers, and our patients could not go to Boston hospitals to receive the services in Massachusetts. They didn't typically need a New Hampshire license because they were physically going there. And when the Boston providers moved to a telehealth platform, they were deemed to be practicing in New Hampshire, which is why we needed to issue all of those licenses so that those services could continue. So it is the existing state of the law. There would be no change in the existing state of the law.
Thank you. This gets to the question of interpretation of the law as to whether, if someone resides in New Hampshire and they consult through telemedicine with a doctor elsewhere, is it clear that that doctor must be licensed in New Hampshire? And my question, you said you gave some justification for a particular interpretation. What I'm asking is, has there been any case law either in New Hampshire first, or if not New Hampshire, elsewhere, addressing that question that you know of?
I'm not aware of any case law in New Hampshire addressing that issue. I am aware of case law elsewhere. I obviously don't have citations off the top of my head, and I could certainly provide that information to you. I would say that it's implicit, not explicit, in the existing statutory framework, because for example, the Physician Practice Act speaks to requirements for licensure, that you need a license to do X, Y, and Z. In New Hampshire, it's implied, right? Because the state can only regulate what's within their border. And then it carves out exemptions, exemptions being consultation services, which implies that maybe the service is actually occurring in New Hampshire, but we're going to carve out this exemption. Also carves out an exemption for if you have an established physician-patient relationship. It carves out that exemption, and you're on the border. So the fact that the legislature felt the need to carve out exemptions, to me, suggests, from a statutory standpoint, that certainly this is the case.
Follow up? Yeah, I mean, I understand that, I mean, that's your interpretation. I'm not saying it, whether it's reasonable or not. Just, if you could send me anything where there's actually, you know, been judicial opinions on that, I appreciate it.
Sure,
Thank you.
absolutely, Representative.
Representative Marsh.
Thank you, Madam Chair, and thank you, Director Courtney, for taking my question. My question relates to the consultation exemption on line 7. And I'm asking this question in the context of being the chair of the Rare Disease Advisory Council, where that exemption comes into play. There may be some certain physicians who may be one in the country, say in Los Angeles, who knows a particular disease. My understanding of that exemption is that the 329.21.2 exemption allows my rare disease patient to be seen in a telemedicine service in consultation with the rare disease specialist who is, for instance, in California, as long as that patient also has a physician in the state of New Hampshire who actually writes the orders for whatever treatment is decided upon. Is that correct?
Yes, that's my understanding.
Thank you. Thank you, Madam Chair.
I guess I have 2 questions. This, first of all, we're looking at outside of a compact, we're looking at recognition of some folks in some other states. Is there any state in New England that is not in the compact that we're in?
Off the top of my head, Representative, I don't know for medicine.
Okay.
I can get that information to you.
Okay, so then my second question, this amends 310A1G. House Senate Bill 277 amends 310A1I and F, or I. This one's G and F. Do you see any conflict? Do these have to exist together? I mean, I know that one of them involves the emergency licenses that were issued under COVID and whether or not we're going to extend those out to 2024. And this one's along the lines of continuing to do some COVID type of things we did, but it isn't, and it is in reference to licensing. Otherwise this committee wouldn't have it. But do you see a tie-in between 382 and 277?
To some extent, I think the reason why we drafted as creating a new section was so that there wouldn't be conflicts when the bills are enrolled, because we saw that last section. So I've learned my lesson with that. But I think overall portability is a huge problem, and we'll talk about that with 330. These are really Band-Aids, and like 277 is a Band-Aid. I think the state, we really need to figure this out. And have one cohesive solution or two to the problem of portability, because New Hampshire we're not home growing our workforce, so we're attracting it from other states, and I think our licensure needs to recognize that portability is going to impact our ability to meet our workforce demands. So I view it as a Band-Aid. I don't think there's a conflict because of the way that it's written. But I'm hopeful that that over the next session we'll be able to make some decisions.
Other questions? Representative Marsh.
I just wanted to answer the question about the Interstate Medical Licensure Compact, because this is something we dealt with in HHS. It's my understanding that the state of Massachusetts does not participate in that compact, although they just introduced legislation in March to do so.
Well, that's kind of disconcerting, since that's the largest of our neighbors.
And we're all especially.
And it makes sense because they historically have not joined compacts.
In that case, I certainly hope you get a reciprocity agreement very, very quickly, although I understand they're not excited about those either.
Right.
Okay. I do have one question. I've heard numerous advertisements for various websites and so forth that say, you just call us, log on, well, the doctor will talk to you and we'll give you a prescription for Viagra. That's the most common one.
Yes.
No, I've heard the ads. My question is, are those websites and programs practicing medicine illegally?
I would think if they're not licensed, then yes. If there's a New Hampshire patient And we saw that with cannabis, right? During the emergency order, there were a lot of shops that popped open specifically to approve cannabis for New Hampshire patients. But if they're not licensed here, then I would think that that would be considered illegal practice.
Thank you. I thought that was the case, but but I'm not a lawyer. Any other questions? Representative Allegro.
Just for my general edification, how is that enforced? For instance, if somebody orders Viagra from 7 states away?
So that's part of the problem. And that's another reason why we want to clarify that that the service occurs where the patient is located, because often you're in an investigation or disciplinary action, your witnesses are going to be here. The person complaining should be able to complain to the local medical board. But the enforcement mechanism, it depends on the board. Most of them have no enforcement mechanism other than to refer it over to the Department of Justice and the Consumer Protection Bureau for potential criminal and civil action. We, in the last budget cycle, we changed the way we work with DOJ in that sense, and that we're fully funding their 2 positions in consumer, specifically dedicated to unlicensed practice, because it's a huge concern. Medicine does have the capability to fine people for unlicensed practice, but it's hit or miss whether we collect and whether it actually prevents people from, practicing without a license.
Thank you. Are there any other questions? Representative Schmidt.
Thank you, Madam Chair. So in the last bill, and I think you were already here for that, we heard a lot about low numbers of employees in a number of agencies and ways of trying to get at that. But this strikes me as being something that is maybe as bad or worse with regard to all this interstate stuff and telemedicine especially. Are we as bad off? And because it looks to me like we're kind of heading for a cliff where things break down in terms of the ability. You already talked about enforcement and so forth. So you can speak to that?
So if they're licensed here, we can take action. So that's why we prefer them to be licensed, because if we take action on their license, we have obligations to report it to the National Practitioner Data Bank, and if it's other professions, other reporting. And then if they try to get licensed elsewhere, or if the public wants to look them up, they can see it's completely transparent. The unlicensed practice is problematic because it lacks that level of transparency. But generally a licensing board's jurisdiction only extends over their licensees. It probably should be the case, right? Which is why we refer over to DOJ. Was your question more about the workforce? Do we have workforce issues, or is it more about enforcement as we continue to roll out telehealth?
Well, enforcement is obviously a very important aspect, because to the degree you get some kind of an order because somebody's doing something illegal and they say, basically, piss off.
Yeah.
That's a very bad situation, because with the internet, that's going to get around nationwide, worldwide, and so then it grows like topsy. So
yeah, the international stuff is more difficult. With interstate practice, it's a little bit easier. So, for example, if we caught wind that somebody was practicing without a license, but they were licensed elsewhere, we would typically report it to that licensure board wherever they're licensed, because they probably have a catch-all clause that says, agree to practice ethically, which it's probably not ethical to, illegally practice. So that's what it's the people who are not licensed in another state and are just doing things. Those are the ones that I think are most difficult. But DOJ has pursued, criminal and civil actions against those individuals, after investigation. So.
Thank you. So I know in the past we've had big problems with pill mills in Florida, for example, but I'm sure it's not the only state, or maybe not even the worst state anymore, because everything is expanding so crazily. Where there's an opening, it's like water, goes wherever the opening is.
Yeah, so I think the question with respect to the bill has to be whether or not the state has requirements that are substantially equivalent or exceed our requirements. And the idea of a compact or reciprocity agreement really is based on trust of the other state. We're trusting the other state. First of all, they have the requirements in place that are like ours, and we're trusting the other state to vet them. Maybe we don't want to trust the other state to vet them, and then we don't have any compacts and any agreements, but then it takes longer for our people to get licensed, which could impact workforce. So those are the type of policy things that the state needs to consider. I support compacts because I think it, first of all, it recognizes the state's right to regulate people within its borders and to determine the requirements. Ours may not be the same, so if they're not the same, we don't enter into a compact, and it allows us to promote or to allow workforce.
Thank you. Yes,
So,
Representative Schmidt. Once.
Given the fact that we are under duress in terms of timeline and all this other kind of stuff, is it your opinion as OPLC director that this is something that we can and should do right now, this bill?
I think so. I think that there needs to be clarity. Although I think it's clear. I'm an attorney, so it's not clear because we get calls on this every day, and I think it would be nice to be able to point them to a statute saying this is the requirement.
I have a question. You said that there is an exemption for established relationship with a physician. How long? What kind of an exemption is that? And how long does it go for? Forever?
So I believe the exemption on that one is if you're traveling. So let's say somebody in Florida is traveling and they're here temporarily. I think the statute uses the term temporarily in the state. They can still consult with their physician, but down in Florida and don't need a license. And then there's also an exemption for cross-border practice. So if you're somebody who practices on the border, let's say with Massachusetts, and the patient lives over the border, there's an exemption for that as well.
Thank you. Other questions? Okay, I think you've
Thank you for your
exhausted
time.
us. All right, is there anyone else who wishes to testify on Senate Bill 382? All right, seeing none, I will close the public hearing. And we have 12 minutes before the next one. Okay. Welcome back. This is a public hearing on a non-germane amendment to Senate Bill 330. The notice was a little confusing because it repeated everything the bill did. The non-germane part on which we are going to concentrate is the OPLC Oversight Committee, which Representative Schuett will be presenting.
Thank you, Madam Chair. For the record, I am Representative Diane Schuett. I represent Merrimack 20, the towns of Pembroke and Chichester. The original amendment that you folks had, I believe everyone on the committee got a copy of Amendment 1424, which is what the hearing today is advertised for. And I will say that, let me just be sure what I'm looking at here.
Yeah. The new section starts on page 2, line 14.
Right, and it addressed the original committee that was in Senate Bill 330 as it was introduced, Senator Gaida as the prime sponsor and our chair as one of the co-sponsors. At the suggestion of our chair, I added the portions of the study that we killed from Senate Bill 313 that addressed funding, part of the funding issues for OPLC. That was added into this amendment 1424, rather than create two separate studies, just have the study that was in this bill add that to their duties. Then if you look on page 2, beginning page, line 16, again with some oversight from our chair, I worked on the language to create an oversight committee to try and examine some of the issues that we've heard between interactions of various boards, commissions, councils, and the administration portion of OPLC. And hopefully an oversight committee, somewhat like the Oversight Committee for Health and Human Services, would be able to hear some of these concerns, suggest remedies, and hopefully smooth things out so that the operation of all the boards and commissions is a little more smooth. Other than that, if I can answer any questions, I will try.
Representative Lekis.
Thank you. At least initially, just one on the new section, line 32 on page 2. And it's saying, you know, who all should be, could bring things to the attention. I would suggest, given that the whole purpose of occupational licensing is at least nominally to protect the public, that it should have said and members of the public, but should. I don't see it in there. And that's, then a follow-up, if I could.
Follow-up?
Yeah, at some point, I'd like an explanation of the part dealing with the repeals and the interaction with the original bill and the Wrestling Commission and all that. Thank you.
I will answer the second part of your question first. I did include language talking about appeals. However, the drafting attorney objected to that language, stating that appeals are something that need to be adjudicated by courts.
The repeals, the section on page 3.
I'm sorry, where?
Page 3, starting line 3. And how that, what would the whole bill look like if we adopted this? That's all.
You know what? I think I have a bad copy of my own amendment.
About this, the repealing of these things. Why do you have that?
Well, I'm not sure. That's what I'm looking at.
You're looking at this thing. Is it this one?
No, this, I haven't presented that yet. Why don't I have a good copy of this amendment?
Here it is. It's right here.
Thank you. Sorry. Now then, I'm sorry. Line 3, did you say?
No, this is not a rewrite amendment for those who are trying to follow along. It only affects the sections of the bill that we are that are being changed. Section 2 is which is the study committee. That is changed by the addition of duties from a different study committee that we're combining with
The
it.
funding portion from
Right.
313, correct.
And then all after section 9, we're adding a new oversight committee, which is brand new language.
Right, the
Sections
rest-
3 through 8 are unchanged by this bill. Representative Schuett also has an amendment that also deletes the boxing and wrestling commission change. But
There's
that's
a,
not
there's
in
a
this
second
one.
amendment to 330
But
outside
the-
of 4142, whatever this is,
Yes,
425.
this,
Okay.
the part of this amendment that is totally new and that we were recommended to hold a non-germane amendment hearing on is section 10, the oversight committee. Okay, thank you. Sorry for the interruption, but please proceed, Representative
Thank
Schuett.
you. I appreciate the assistance. Unfortunately, I had a different draft of the amendment. I'm not sure how that happened, but we went through a couple different iterations trying to craft the language. And it's true, the rest of the bill was not my intention to be affected, just adding the funding to the original study and then the oversight committee. And I leave it to the committee members if they feel somehow the public should be included in some of that language. I'm not sure, perhaps Director Courtney can answer. I don't know if the public is actually involved in interactions of OPLC and their boards and councils, or to what extent.
The boards have public members. And most of the complaints come from the public. Okay, are there other questions? Representative Schmidt?
So I'm wondering, I mean, I hear where you're coming from, Tony, with regard to the idea that a member of the public maybe should be involved. The problem is that even in this committee where we deal with all these things to some degree on a regular basis or have in the past, a member of the public is going to be just overwhelmed with all the various different aspects that he or she might have to be involved in, and they might or might not be more trouble than they're worth in terms of being able to be helpful. Even if I like the idea of maybe getting some kind of a genius that could help, I'm not sure we have any geniuses who want to take this on.
Yes.
So,
Did you have a question, Representative Schmidt?
well, the question I have is just since Representative Schuett says she has a funky copy, are we all looking at 1424H?
Yes, I have the correct, Representative Grota found the correct copy for me. And I will point out that the original study requested in 330 is designed to report by, I believe it's November 1st of this year. And the Oversight Committee is to take effect January 1st of 2023 to be able to perhaps utilize whatever the study originally in 330 may come up with as suggestions or things to be looked at.
Representative Lekis?
Thank you. I just wanted to clarify the question I was asking. And it was on the section 3, page 2, line 32. I was asking if you consider adding members of the public to the list, not as a member of the committee, but as, the group of people that might bring issues to the attention. It says, as brought to its attention by the office personnel, legislators, it goes on. And I was just wondering if there was a reason why members of the public was not included in that list, not membership of the committee.
Okay, Representative Schuett, you have a,
I would just say that, as with Health and Human Services Oversight Committee, members of the public obviously can attend, listen, and hear the reasonings, what have you, for whatever interactions they're examining. They also examine interactions between healthcare providers and the agencies of the state.
Just a brief follow-up, if I may. Yeah, I know it's a public hearing and they could attend, but my question was that they could be people who would be recognized as people who could bring issues before the committee. That was the question.
Representative Grota?
Thank you, Madam Chair. So, Representative Schuett, my concern is that am I understanding this correctly, that this oversight committee would not sunset, it would just be permanent?
No, there is a sunset provision, part of the repeal that you see, line 5. The Oversight Committee is due to sunset, and it's under the effective date, paragraph 2, sunsets January 1st of 2028. So it would have a 5-year lifespan. And if the Oversight Committee determines that there is enough reason to continue, the legislature could choose to do that. But right now, it's built in with a 5-year life.
Follow up. So the oversight committee would run in tandem with the study committee. The study committee and the oversight committee would run in tandem. Are they the same people?
No. I believe we need to add a repeal of the study committee after it issues its final report in November of 2023.
Okay, that's my confusion.
That would
Thank
be
you.
the
Okay.
appropriate way to do it.
Okay, thank you.
Yeah, as I stated, that's why we made the effective date of the Oversight Committee January of 2023, because the study committee technically is supposed to do a report on November 2022, and then a final report November of 2023. But if the Oversight Committee has issues that were put forward by the report on November 2022, they could begin looking at those issues.
So I guess if we were to take Representative Lekis's suggestion to include members of the public, would that not cause confusion as to what the lines of communications are? Because is the public now not going to OPLC with their complaints? And this can, if I understand correctly, this oversight committee is just to discuss the issues between the board and the director. It's not the function of the OPLC. Is that correct? Okay.
That's my intent.
Yes, you may have noticed this year we had a number of bills dealing with the relationships of the boards and the OPLC. And we decided that since the OP has become larger and larger, that's something we ought to keep an eye on regularly.
Thank you.
Are there any other questions, comments, concerns?
I would state that if the committee chooses, we could change line 12, just delete line 12 and leave November of 2022 as the final report date on the original study. I believe we could make that change without a major amendment change.
Mm-hmm. Okay. Thank you. Are there any other questions for Representative Schuett, Representative Sitek?
Is there a second amendment for the boxing and wrestling?
There is a second amendment which basically mirrors 1424 with the exception it deletes the Boxing and Wrestling Commission, which we sort of took a straw poll before, if you'll recall, that this committee agreed that that should not be regulated by OPLC. That's the only change.
And that's the one that will be presented at the executive session.
With,
It's,
we will only see one amendment at the executive session. All right,
Yes.
Okay, all right, that's all. We don't usually have two amendments.
it's simpler if we don't, yes. Any other questions? All right, thank you, Representative Schuett. Director Courtney wishes to speak to us on this amendment.
Thank you, Madam Chair. For the record, Lindsay Courtney, Executive Director, OPLC. OPLC certainly doesn't take a position on this bill, or on this amendment, rather. And for the record, I'm looking at 1424. We, being at OPLC the last couple of years, it's been a little bit like building an airplane while flying. So I certainly, would welcome the input, and I think the members of the committee who would serve on this would certainly, I think, find it enlightening as to how occupational licensing is currently working in New Hampshire. My only question or observation is whether or not the scope of the committee's work is sufficiently broad. I know that the committee throughout the legislative session heard probably some grumblings and complaints from stakeholders. We've been strategic in trying not to complain, regarding boards. We have a good relationship with the majority of them. But for example, should OPLC be able to bring issues to this oversight committee regarding boards? True story, if a board is facilitating the commission of a crime and declines to do anything when that's brought to their attention, is that something that we should be able to bring to this oversight committee's attention? As it's currently drafted, it just says the committee shall provide legislative oversight and informational meetings on the policies and rules of the office. I guess my suggestion would be to make it clear that if OPLC observes concerns, that we be able to bring that to the oversight committee's attention. But certainly, we don't take a position on this, and if assume this passes, we look forward to working with the committee. Thank you. I'd be happy to answer any questions.
Thank you. I would hope that if there is a crime being committed, you're reporting it to the appropriate authorities.
I did.
Thank you. Representative Schmidt has a question.
Oh, that was going to be my suggestion. I thought we already had an attorney general's office to handle that kind of thing.
Yes. Whether or not people exercise their discretion to prosecute cases is a separate matter, but I think from a structural standpoint, there are, by and large, our board members have very good intentions. I think the problem with the office has always been, and with the boards, that there's a lack of internal controls. There has been a lack of an inventory over what the statutory regulatory requirements are. The boards and the office historically have just regulated based on how they've always regulated without regard to what the statute actually requires, which is why it's part of our plan to establish internal controls. But so I think that's why we've gotten into a situation where we stumble upon issues like this. And even with best intentions, there are a decent number of legal issues out there that I would think would be appropriate to bring to this type of a committee.
Follow up?
So I do understand that there's a difference between things which are illegal and things which are crimes. And certainly that's one of the advantages of this new oversight committee is to try to sort some of this out, because otherwise you're just doing too much all by yourself and without enough help from us.
Thank you.
Thank you. Are there any other questions? Representative Bailey?
Do I understand it to say that you'd like it to flow both ways? It's not
Correct.
just us overseeing you. You would like to be able to have us oversee these boards if you get into trouble with them.
Correct,
Or
because
disputes or
correct, Representative. Because I mean, I know that the boards, I shouldn't say all of them, but several of them may feel differently. But if you actually look at OPLC's authority, it's quite limited. And if you look at the board's authority, it's generally not limited. They have, oftentimes full discretion to regulate what happens in their profession. So, there are things. I think that it should go both ways. I think that for the most part, we've got 54 boards. We've got a good relationship with about 40 of them. 15 of them you've probably heard from. But I think that there could be improvements on both sides.
thank you.
Other questions? All right, thank you very much. Is there anyone else who wishes to testify on this amendment to Senate Bill 330? Okay, not seeing anyone. Close the public hearing. We'll resume at 3 on Senate Bill 333. Everyone stand up and stretch.
Did she know of any, no, did she know of any other boards that did this?
She's not saying. Oh, she said yes, there's a few of the very old boards that are, that have that authority. She's going to send us a list.
Okay. I wonder if it's ever been used. Well,
Recently, at least. We're going to.
so do you have an idea how long they're going to go this up?
No. We're being kicked out of the building at 5.
Well, I have to leave it at some point because I have to pick somebody up from the airport. So.
Okay.
Okay, I'm just giving you some advance.
Thank you.
If I run
No
out
problem.
suddenly, you won't be offended.
Yeah, well, Jeff had to take his mother to the
Breathe a
doctor.
sigh of relief. Who knows?
Who knows? One or the other.
Be nice to hear how Mike's doing.
Yeah, that would be nice. Hope he's okay. Bleeding all over the committee. It's not a good.
No.
Just want to put a face to the name. I'm Simon Thompson.
Oh, yeah, right. I have found, by the way, that there are other boards that can do what I objected
Just
to.
asked Lindsay, and she said both of them can.
Not most, hold on, some of the old boards. that doesn't mean that that I like this. The fact that I voted against, thanks.
Yes, information for everyone. The building closes at 5, and if anybody feels the need to stay longer than 5, I wish you luck.
It won't be me.
Yeah. All right. What lovely timing. Okay, it's 3 o'clock. I'm opening the hearing on Senate Bill 333, and I call Senator Avard.
Thank you, Madam Chair and committee members. For the record, I'm Senator Kevin Avard. I represent District 12, 3 wards of Nashua, 1, 2, and 5, Hollis, Brookline, Mason Ridge, New Ipswich, and Greenville. And I am the prime sponsor of Senate Bill 333 with regards to case management. And is there an echo in the room? There we go. That sounds a little better. Case management agencies have been licensed in New Hampshire for 28 years by the Bureau of Health Facilities as home care providers under RSA 151-2B. Since the initial passage of HEP 819 through GELCAR on May 27, 1993, the license of these agencies is critical to ensuring the health and welfare of citizens that they serve. The enabling statute was originally RSA 151-2B, which this bill seeks to amend and is appropriate place for the language before you. The original license issued under HEP 18 stated that home care provider, quote, case management, there was no legislative actions which directed the department to alter this. During the course of rule revision through GELCAR, the enabling statutory authority was erroneously changed to RSA 151-2 FF, adult daycare services. The case management agencies do not provide adult daycare services, and federal regulation prohibits them from doing so. The department amendment is problematic as it has unintended consequences, and the department amendment creates a substantive change from the practices of the last 28 years without explanation as to why this monumental change is being requested.
Excuse me, Senator?
Yeah.
What department amendment are you talking
There's
about?
there's an amendment from the department, so that'll be coming, I'm pretty sure, or, so.
Thank you.
Yeah, it should be noted that three of the four from 1915 community-based care waivers, DD, IHS, and ABD, are under the plan of correction for providing case management services which are not in compliance with federal law, which requires that the case management be provided in a manner in which is free from conflict of interest. The department amendment has unintended consequences of limiting solutions before a plan is in place to resolve the deficiencies by CMS. The independent case management agencies have been providing services under home care statute for 28 years. They serve individuals in the community and individuals wishing to transition back into the community under Medicaid, private insurance, and private pay. There are significant cost savings, which results from keeping our citizens out of nursing homes. I urge you to support my bill, and there are some folks here that will talk more specifically. If I could have technical questions directed at them. I just want to point out, in real life case, I was called by a constituent this weekend, and I could put it on speaker because she left me a voice message. Senator, my name is such and such. I'm a quadriplegic. I can't find somebody to get me in and out of bed. I need help. I called some people that were in the room to help out with this particular case. There are people that she said, I can't find somebody. And I immediately went to Caroline Virtue, who will be speaking about this bill, to help provide this individual with help. I think that if this doesn't pass, the people that have been serving the community and that advocate for those in such circumstances, if they're not around, I don't know how you would help somebody like this. So anyway, I would ask you and beg you to ask any technical questions for those that are here to testify in support of this bill. It's been a very long day, and I really appreciate it, and I hope that you do pass this bill, and I thank you.
Thank you. I'm trying to, do I understand you correctly to say that this operation has been proceeding until HHS changed their rules and now the case management businesses do not comply with the rules and therefore they'd be going out of business?
That is my understanding, and as I'm trying to convey to you, yes. And,
Thank
and
you. I
I
just
wish you
wanna
to
make it
testify
clear.
for me instead. Thank you, Madam Chair.
All right, thank you. Are there other questions for the senator? Okay. Thank you very much. Carolyn Virtue? If I see you have written testimony, if you could pass it out, and if anyone else also has written testimony, pass it out at the same time, please.
Madam Chair, my written testimony is with Jeb Curlup and Heidi Kroll, so may they please go first? Thank you.
We'll do them first. Heidi Kroll and Jeb Kroll.
You want me to pass some of those out?
Good afternoon, Madam Chair and members of the committee. For the record, my name is Heidi Kroll. I work at Gallagher, Callahan, and Gartrell, and I'm here today on behalf of Life Coping, which is a case management agency based in Nashua with a statewide footprint. And we are in support of SB 333 as amended by the Senate. And I wanted to just briefly, before I start discussing the bill, allow Jeb Curlup, who's the principal of Life Coping, to just briefly explain what case management agencies do.
Thank you, Madam Chair and members of the committee for this opportunity to speak. My name is Jeb Curlup. I'm with Life Coping Case Management. We're a case management agency located in Nashville. We provide case management throughout the state of New Hampshire. Life Coping is an independent, licensed, conflict-free case management agency, which means we only provide case management services to our clients. We do not provide any direct services to them. Rather, we conduct a comprehensive needs assessment of the patient's clinical and non-clinical needs, develop a care plan, and help find the appropriate service providers. The case management we provide is a healthcare service, specifically home and community-based care for the elderly and chronically ill who are eligible for a nursing home level of care. So these individuals would be in a nursing home otherwise. Case management agencies have many nurses and social workers on staff who regularly assess their clients' medical and non-medical needs and coordinate their care so that they can safely live at home. Life Coping serves clients who are eligible for services under Medicaid waiver programs, specifically Choices for Independence, developmental disabilities, acquired brain disorder, and in-home support.
So SB 333 is really intended just to be a very simple housekeeping bill. The issue is that, from our understanding, HHS has recently taken the position that their statutory authority to license case management agencies needs to be clarified. This came as a surprise to us because HHS, as you heard from Senator Avard, has been licensing Life Coping and similar case management agencies for nearly 30 years pursuant to RSA 151:2B, as well as HHS rules to carry that out. SB 333 is simply meant to clarify the department's authority to continue licensing case management agencies and really essentially maintain the status quo. Life Coping fully supports licensing of case management agencies. From our perspective, it ensures critical consumer protections and quality of care for vulnerable populations that the case management agencies serve. Again, those are elderly and disabled who would otherwise, who are eligible for a nursing home level of care, but are able to stay in their homes and in their communities. Licensure also ensures that case management agencies are held to the same high standards that are applied to other healthcare providers, and it protects New Hampshire's federal matching funds. It also allows a certain case management agencies to be eligible for critical federal grants. So we would like to explain from our perspective where we stand with the law and the rules. So RSA 151 is the Residential Care and Health Facility Licensing Statute. The phrase case management agencies is only explicitly mentioned in RSA 151:5, which is the section where license fees are listed. The phrase case management agencies is not explicitly listed by name in the list of entities that appear under RSA 151:2, which is the section about license or registration required. However, case management agencies are implicitly listed there, specifically under RSA 151:2, Roman 1, parentheses B, which refers to, quote, home healthcare providers as defined in the later part of the statute, 151:2-B. And when you go and read that definition in RSA 151:2-B, it reads, and I quote, home health care provider means any organization, business entity, or subdivision thereof, whether public or private, whether operated for profit or not, which is engaged in arranging or providing directly or through contract arrangement one or more of the following, and then there's a list of services that clients, patients could be eligible for. So case management agencies like Life Coping are a business entity which is engaged in arranging one or more of the listed services that their clients need. Case management agencies have and should continue to fall within the definition of home health care provider and the licensing authority there. And in fact, at one point, Life Coping's licensing application actually referenced home care provider / case management. And you heard earlier Senator Avard refer to the rule. It's our understanding that HEP 819, which is relative to case management agencies, used to reference 151:2-B, and however, at some point along the way, the rule was changed, an error was made, and it now states that a license to operate a case management agency is pursuant to 151:2 Roman 1F, which is a reference to adult daycare services, and that's clearly wrong. We don't know why. You may hear that case management agencies have not been licensed or should not be licensed under the home health care provider statute. And we would like to share 3 items with you that demonstrate that case management agencies have been licensed under the home health care statute and should continue to be licensed under the home health care statute, which again, this simple fix is simply meant to clarify. And in one of the handouts I gave to you, first is that in Department Rules HEE 805, it defines case management agency as an agency that is licensed in accordance with RSA 151:2 Roman 1 parentheses B. And again, that's the law that says license is required for home health care providers. Secondly, another piece of evidence that we have been and should continue to be licensed under home health care is that in March of 2021, a report was issued by the Department of Health and Human Services about findings and recommendations on New Hampshire's long-term supports and services for seniors and individuals with physical disabilities. And the report reads, and I quote, "Consider contracting with case management entities directly rather than having them licensed as home care providers." through the standard Medicaid provider enrollment process. So that is straight from the department report, that we are licensed as home care providers. And finally, a third piece of evidence is that case management agencies that they have been licensed under the home health care statute is in HEP 819. Those rules say that licensed case management agencies must comply with the Home Care Client's Bill of Rights, which is set forth in 151:21B. And when you read that statute, it says that these client rights apply only to services delivered by or on behalf of a home health care provider. So this is yet further evidence that case management agencies are licensed under the home health care provider statute. So in summary, SB 333, as amended by the Senate, simply adds case management agencies explicitly to the definition of home health care providers in order to clarify that HHS does indeed have the statutory authority to license case management agencies under that statute. This, in our opinion, will preserve the status quo with respect to licensing of case management agencies that serve individuals covered by Medicaid, as well as by private insurance and private self-pay patients. We thank you for your time and your consideration, and we respectfully ask for your support of SB 333 as amended by the Senate.
Thank you. Are there any questions from the committee? Representative Fellows.
Thank you. I'm hoping I'm not getting the part about why the case manager. I don't understand the distinction between case management service provider and case management agency, and I also don't understand why there's an amendment to add case management in that existing paragraph that begins with home health care providers, and why case management doesn't have its own little paragraph.
Right, so I think the case management services provider and case management agencies is probably one and the same. I think it is one and the same. And to answer your second question, that's where we have been. In our opinion, that's where the authority has come from to license case management service providers or case management agencies. It has come from this authority to license home health care providers. And that's this information that I was just going through, where there are a variety of pieces of evidence from over time kind of supporting that. And in fact, from our perspective, Life Coping is a business entity, a private business entity, which is engaged in arranging through contract arrangement one or more of the following services for our clients. So that language, we think that, and that's been there, that's where we think the authority comes from, but the department is saying that it's not clear. And so we are simply proposing to add, including case management services provider, to make it explicit.
Thank you. We appreciate your concern for clarity. Any other questions? I have one. Oh, Representative Broda.
I'll yield to you first, Madam Chair.
Okay. Yeah, my concern is the HEE 805 rules are 5 years old at this point, and the 819 rules are not yet online. And I'm wondering where are they? When were they passed?
My understanding is that the H19 rules have been on the books since 2013. No?
Okay.
Well,
so they're not new. Okay.
I don't know. They are not.
So
new.
my concern then is what's happening now that causes the need for this. Why, if one set of rules is 5 years old and another one is 9 years old, what is the need for doing this?
That's a great question, Madam Chair. So we had a piece of legislation last year, which ultimately a provision went into SB 162, which initially started out as a discussion that was supposed to be a discussion about talking about homeless shelter case management. Ultimately, when it got put into SB 162, it was kind of watered down and talked more just about talking about licensing of case management. And the department under that law was supposed to hold some stakeholder meetings. And we actually only had one that was held in the fall, the early fall with the department. And it was on that Zoom call that we learned that the department felt like they were lacking statutory authority to license case management agencies. And as I said, when I began my testimony, that was quite a surprise to us because we have been licensed for approximately 28 years, and these rules are not new rules.
Okay. And, all right. So, actually, if it was from 2013, I mean, that would imply that it's over 9 years old and it's about to expire next year. So that's why it would be coming up for revision. Okay. Thank you for clearing that up, Representative Grota.
I think that this was my question was, where does this kind of like hairball start? And it seems to me that it was with SB 162 and an amendment that was not really targeted, that ended up not saying what it wanted to be, and then therefore confused homeless shelter with case management. Is that what you're saying?
Initially, there was I think it initially started out as SB 140, but then ultimately the language was put into SB 162, and there was discussion about the department getting funding for case management with respect to homeless shelters. And the phrase case management kind of caught our attention given the business. But ultimately I think initially, at least our understanding was there was supposed to be a discussion around case management in the context of homeless shelters. But ultimately, when it went into SB 162, it was blurred, I guess, a little bit, or to have a discussion just about case management licensing. And that's when we had, like I said, a Zoom call in early fall with the department and other stakeholders. And that's when we first learned about the department's concern about feeling like they didn't have the statutory authority to be licensing us.
Thank you.
Interesting. Any other questions? Representative Schmidt.
Thank you, Madam Chair. So this is a little bit of a handful here to grasp all this, because it's a little bit about what you see is not what you get. Anyway, so has there been any further action involving, has anything gone to court?
No, there's nothing. I mean, the case, there is no court issues.
Okay, that's the answer is no. This homeless shelter thing, it sounds like that was kind of appended on to the existing business that you've been doing for a long, long time.
The homeless shelter issue, I think, kind of got resolved through other legislation. So the department removed reference to case management around homeless shelter, and they got the allocation of money that they were looking for, and so
that went away. That went away.
Yes.
That went away. Okay, so we don't have to worry about homeless shelters anymore.
Correct.
In context of this bill. Follow up?
Follow up.
Okay, so, and have you done any exploration with the feds? Because presumably if the department is saying, we don't know that we have the authority to be doing this at all, or adequate authority or whatever, then I would think that there would have been some inquiries with the feds to find out whether that was the case, whether you were on you guys were on solid ground, or whether this was 28 years of being done this way and it never should have been done that way. Because that's kind of sounds to me like that's where the department is. They're kind of saying, we don't think we have the authority to do this.
Well, I think the licensing is a critical piece. Can you hear me okay? I think the licensing is a critical piece for a variety of reasons, including the state of New Hampshire getting federal matching funds, as well as I mentioned in my testimony, some of the case management agencies with their licensing that's a criteria in order for them to be eligible for federal grant money. So I don't think there's any question about the need and the authority for licensing. It's just that the department is looking at RSA 151 and not seeing explicit authority to license case management agencies. And that was news to us because the paragraph I read to you, we do feel like we qualify as a business entity which is engaged in arranging through contract arrangement more of the following services for the clients we serve, and we have been licensed under that statute for approximately 28 years. So we were surprised to hear of the department's concern, but we think this is really purely meant to be a housekeeping item with respect to just inserting explicitly the phrase including a case management services provider to just make it crystal clear.
Okay, so I'll stop
Follow up.
asking questions for the moment and let some of my colleagues continue.
Representative Blackus.
Thank you. So have you had consulted with the department and, if we added this language, would they feel comfortable that they have the authority to provide the licensing you're looking for?
The department is, I think, wants to put the authority in a different section of RSA 151. And our concern with that is that I think we're concerned that it would have unintended consequences, given that we have been licensed under 151 :2 -B. As an example, we pull it up here. The third example I gave before about that case management agencies are required to be compliant with home care clients' Bill of Rights. As an example, the licensing rules require that. But when you go back to the law, you see that that provision about compliance with home care clients' Bill of Rights only applies to services delivered on or behalf by or on behalf of the home health care provider. And there are, I think, other things along those lines that we're concerned if we put the statutory authority in a different place, we would have unintended consequences.
Follow up.
Okay, but they may prefer it somewhere else. You may disagree, that's fine. But the question is, if this bill were passed, do you have any assurance from HHS that they would be convinced that they have the authority to provide the licensing you want?
I do believe that it would clearly give them the authority. Yes.
But you follow up, I mean,
Follow up.
you don't have that clearly from them. Is that true?
I don't have that from them.
Okay, thank you.
Okay. Other questions? Representative Fellows.
Thank you, Madam Chair. I didn't catch what, do you work for a healthcare management provider?
I work at Gallagher, Callahan, and Gartrell. I'm a registered lobbyist for Life Coping.
Is that who you're
My-
representing?
Yes, I'm representing Life Coping, yes.
And
This is Jeb Curlup, and he's the
what is your organization?
principal of Life Coping.
What is your organization?
Our organization is Life Coping. We're a case management agency. We provide case management throughout the state of New Hampshire and have been for the last 30 years. This program that we work on that we're for the licensing, none of this is this isn't really alien to the federal government. These programs exist virtually through every of the 50 states in our country. The purpose is to help individuals to remain safely and independently at home with services and out of institutions. So this would be for nursing homes, where you'd be keeping people at $72,000, $75,000 a year. With our program, we'll keep them in the community for $15,000 to $20,000 a year. So you take that $55,000 savings, multiply that by 4,000 people, and you've got several $100 million a year that you're saving. Our agency's been licensed since the case management agencies have been licensed for the last 28 years. We've got a copy of the license here. And as far as the federal approval or authorization or authority, or these programs are going on throughout the United States. Every state has a program like this. We came into this issue with the department when there was a RFP for case management in homeless shelters, and then there was a question about who would be providing the case management in the homeless shelters, and then out of that grew where we are today, with the department saying that they don't or may not have statutory authority to license case management agencies. So we're saying that basically they have been licensing us for the last 28 years. I've got our license right here. We have the language that's in the RSA that refers to us under the home health care providers. And basically, these are people who would be in nursing homes, or they would have been in the Laconia school, which was shut down years ago. But it's helping these people to remain safely in the community as far as CFI, with great savings to the state. So it's not an alien or really unusual program. These are going on throughout the United States.
Okay.
And I would just add,
Representative Schmidt.
Thank you. Well, I am not a lawyer and I don't play one on TV either, but I have some familiarity with a legal concept called laches, which says that if you've been doing something for a long time, you can't suddenly be deprived of the right to continue to do that without very good cause. So is that some aspect that you've explored, especially with legal counsel?
we have not. No, I mean, I think there's consensus that we should, I hope there's consensus that we should continue to be licensed as we have been. It's just literally a house, and from our perspective, a housekeeping item to just be very explicit in the law rather than having to read the words that I read to you earlier, where you kind of have to piece together out of that paragraph how we fall into it. And I just did want to mention there was reference to the license, and that is included in the testimony that we handed into the committee.
Thank you.
Thank
Other
you.
questions? Representative Fellows.
Thank you, Madam Chair. I didn't actually even get to my question. So my question was, I was trying to find out, so you are you do case management services. Do you also provide home health care services, such as sending an aide to the home, and do you only refer to other places for the actual service provision?
Excellent question. We are a conflict-free case management agency, which means that we provide exclusively case management services, and we do not provide any direct services. So I'm not deciding what services your mother may need and then providing those services. And that's something that the federal government, and actually the state of New Hampshire, is in the process of a corrective action plan for conflict-free case management. And that's a really actually a very good point in terms of what might be just totally a consequence of what not licensing case management would do. And basically, the state is being assisted now with its conflict-free case management plan as a result of having, I think New Hampshire's we're a unique state in that we do have independent case management agencies, and many states don't, and many states are struggling with this whole concept of the conflict that you alluded to. So, thank you. That's an excellent question. I hope I've answered it.
Other questions? Ms. Kroll, would it be fair to say that the 819 rules on case management are expiring in January? Is the department's concern part of their process of updating these rules? Or do you know anything about these?
I don't want to speak for them, Madam Chair.
Okay, fair enough. I shouldn't have asked. Any other questions? Seeing none, thank you very much.
Thank you.
Alex Kutrubis.
Thank you, Madam Chair and committee members. My name is Alex Kutrubis. I'm here on behalf of my client, the Community Support Network, which is the association of the 10 area agencies that provide services and supports to individuals with developmental disabilities and acquired brain disorders. We did not take a position on this legislation in the Senate. However, we are here with some concerns about it. And really the reason is, as introduced, the bill just added 5 words, including a case management agency, to the definition of healthcare, home healthcare provider under RSA 151, which is, as you heard, the Residential Care and Health Facility Licensing Statute that's administered by DHHS. Several weeks after the public hearing in the Senate, there was a replace all amendment that we believe has altered the scope and reach of the legislation. In general, we believe that this bill, as amended by the Senate, is ambiguous and confusing. For example, the language on line 6 adds case management to the definition of home healthcare provider. This action would lump case management with a long list of direct service providers that are on lines 8 through 11. Yet if you go down to line 22, it says case management activities shall not include activities which constitute the direct delivery of other services. So why are we amending a direct service definition to include case management? At the bill's public hearing in the Senate, HHS offered an amendment to solve at least one of the stated goals of this legislation, but again, the bill as amended by the Senate is not what was proposed by the department. And obviously this is concerning because HHS is going to be the state agency that will administer and enforce this law. The suggested language and history of this issue was contained in a letter that was sent to Speaker Packard, dated November 18th, 2021. It's also unclear to us if the purpose of this bill is to merely license the entities that have historically been licensed, or is it to expand licensure to new entities? And again, if you look at the letter that was sent to the Speaker of the House,
We don't have that letter.
well, it's not my, it's a letter from HHS. So I don't want to speak for them or present their letter, but I'm happy to get you a copy of it. But in that letter, there's concern that mental health, housing, children's services, developmental disabilities could be pulled into requiring a license for case management if we don't amend this statute correctly. We're also confused about the general purpose of this bill. There were inconsistent reasons provided for why this bill is here. There were inconsistent reasons, I think, provided today. For example, you heard it was an administrative fix. It's a housekeeping bill. But the sponsor said today, we talked about conflict of interest and how some of the Medicaid waivers are out of compliance. Is it a bill to get us into compliance with conflict of interest, or is it just to license the people that have been licensed for 28 years? I think there's a lot of different statements that have been made, and I think we need to get some clarification on that before we pass the bill. If it's an attempt to try and enforce the conflict-free case management issue, we see some problems with how it's worded in the bill as presented here. As you heard, conflict-free case management requires that the assessment and coordination of service is separate from the delivery of service. And the goal is to limit any conscious or unconscious bias that a case manager or a case management agency may have. HHS is currently working with all of the stakeholders to get New Hampshire into compliance. They're working with CMS, Centers for Medicare and Medicaid Services. They're working with the area agencies. They're working with the independent case management companies. We already have a plan in place. It's a corrective action plan, as you heard, and the goal is to be in compliance by August of 2023. It's also important to note that, adding again to the confusion of this issue, the words case management or case management service provider do not appear in RSA 171, which is the law that governs developmental disabilities. Case management also does not appear in the administrative rules, HEM 500, that clarify 171A, which again is the DD statute. DD uses the term service coordination. And again, because of these issues, I think HHS's amendment is the way to go. We shouldn't be trying to regulate a human service system that's governed under 171A under 151. It doesn't make any sense to do that. And you heard about conflict of interest. I think this bill, as presented by the Senate, has a lot of conflicts of unintended consequences. And again, it goes back to the issue of conflict of interest. There are exceptions under the federal law for conflict of interest. For example, if you can demonstrate that the only willing and qualified case manager for the individual who needs the service is also affiliated with the direct service provider, you can have an exception if there's a lack of service providers. And obviously we have a healthcare workforce shortage in the state right now, and we don't want to put something that's overly broad in the statute that could deny people services. But again, we are working to get in compliance with the conflict-free case management issue, but we have to do it in a thoughtful way over time, phase individuals in. The system as it's configured, the developmental disability system as it's currently configured has been in place for a long, long time. And it's going to take some time to unwind that, which is why we need to take our time and make sure that we do it correctly. So again, if we need to amend the statute or amend the rule to come into compliance with federal law, DHHS knows how to do that. They're not shy, as you know, about coming to the legislature and asking for changes. They are not asking for this. So I think we need to be very cautious about amending it if they're not in agreement and do not feel that it gives them the correct language and the correct authority to do what they need to do, whether it's conflict of interest or whether it's to license the existing case management companies. If the goal of this and the purpose of this is just to license the independent case managers, as has been the case for many years, we have no problem with it. But we think it goes beyond that at this point. So thank you, Madam Chair.
Thank you. I believe, is there a question, Representative Rhodes?
Thank you, Madam Chairman. Throughout your testimony, you repeatedly used the terminology, we are working to fix this, or we are working towards addressing, becoming in compliance. Can you just be very specific on who is we?
Well, it's a broad group of stakeholders. There's a variety of work groups that DHHS has formulated around the conflict-free case management issue. So anyone is welcome to join those groups, but it's really being spearheaded by DHHS. But anyone who's a stakeholder is part of those groups at one way or another.
Thank you. So there was a question asked by a representative to the people that testified prior to you about DHHS, and if I'm not mistaken, it was being on board with this. And if I'm not mistaken, they had said that they believe that they were. Are you saying that DHHS is not?
I don't want to speak for the department, but they're not on board with this. They provided a letter.
Oh, good. Okay.
They provided a letter in the Senate that suggested language to solve this issue. That is not what is before you as amended by the Senate. It's a completely different bill. It's a completely different rewrite.
So I'll let them speak. Thank you. Apologize.
Yes. Any other questions? I have one. Representative Bailey.
Thank you. Didn't we hear earlier that DHS doesn't really want anything to do with this?
I don't want to speak for the department, but I believe that they want to continue to license case management agencies. But
Okay.
I'll let them
We
address
need to
that.
let them speak for themselves,
Absolutely.
so
I
please
agree.
don't ask any questions about what DHS intends. But I would ask you if your concern is that this legislation appears to muddle the case management of the home and community-based care organizations, which these people are talking with the developmentally disabled case management, which is, I would assume it would be fairly similar in what you do, but it's driven by different statutes. Is that correct?
Yes, I mean, the case management functions are very similar, but it's a different system. It's configured differently. And historically, the DD system, case management has been a part of the delivery of the service. And again, we're trying to unwind that slowly over time in consultation with CMS and all the stakeholders.
So
But yes, we need to amend the correct statute.
And so that in your case, the development, the disabled case management is where the conflict-free case management issue may have arisen because you did have conflicts.
Yeah, correct. There is no conflict with the CFI case management. But there is still, but we're working to change it. There is conflict with the DD case management, which is why we're under the corrective action plan.
Thank you. That makes things a little clearer. Thank you. Are there any other questions? Representative Fellows.
Can I just get you to repeat those last two sentences without acronyms so I know what?
So we have four waivers, Medicaid waivers in the state of New Hampshire, home and community-based waivers. They, three of them are considered developmental services waivers. One is the DD waiver, developmental disabilities waiver, which is for adults who have developmental disabilities. One is called the in-home support waiver, which is for children under the age of 21 who have severe disabilities. And we have the acquired brain disorder waiver, which is people who have, over the age of 21 who have a brain injury who need services and supports. Those three waivers are under a corrective action plan with the federal government. And I think this bill is attempting to put pressure on New Hampshire to get into compliance with that. But that's not where
Not
this.
speculate on
well,
what the
Well, that's what the sponsors
goals
said.
are there. Okay.
He said that this could be used as a tool to enforce that law.
Thank you. Are there any other questions? Representative Schmidt?
I think the chair's earlier remark about hearing from the department is appropriate at this time. So we don't speculate about what the department says. We hear it from them.
You're welcome.
Melissa St. Cyr? You said you had written testimony.
So yes, good afternoon. For the record, my name is Melissa St. Cyr. I'm the Chief Legal Officer for the Department of Health and Human Services, and I oversee the Bureau of Licensing and Certification. I don't have any written testimony. I have a proposed amendment which amends the current language that was passed out of the Senate. I'm happy to distribute that if the chair would like.
First, explain to us why we need
Sure.
what your intentions are, because that appears to be the subject of a great deal
Sure.
of speculation.
Absolutely, happy to do so. So, Heidi Kroll was correct. We did convene a stakeholder group. We were asked to do so by the legislature to review case management and the licensure of case management and come up with a plan. While we were doing
Under who in the legislature asked you, and what
it was
the
Senate
method?
Bill 162, Senate Bill 162.
Thank you.
Thank you. And so we began reviewing that At the same time, we are amending our rules for HEP 819, which is the oversight authority for case management agencies under RSA 151. And so while we were doing that, the statutory authority that is listed currently on the rules right now is RSA 151.5. And that is the only place in RSA 151 where the term case management agency exists. And that is the fees section. So it essentially says that people need to be charged a certain fee if they want to be a case management agency. But that's typically not what we would see in a statutory authority to create rules for that licensure. So in an effort to clarify and ensure that case management agencies can continue to be licensed and that there is that appropriate statutory authority when we go in front of GELCAR, we have suggested that we continue obviously to license case management agencies. But what we did was we pulled out the existing language that was in the rules that has been approved by GELCAR for a period of time now, as well as those who are exempt from licensure as a case management agency, one of those being the area agencies. And those currently exist in the rules right now. So we verbatim took them from the rules and placed them in a paragraph and presented that to Senator Bradley. And then Senator Bradley was working and knew that Senator Avard was working with this group here. And so he had asked that we utilize this vehicle and instead of a one that Senator Bradley had to move this language forward. So essentially, when it went in front of the Senate, the language changed to something that was proposed by Heidi Kroll and the group that is their case management agencies. And so we then took that language in an effort to collaborate and amended some of it so that it would be relevant to licensure. So we are proposing RSA that it be RSA 151.2 instead of RSA 151.2b. And the reason for that is that it is not considered from a state licensure perspective. They are not considered home health agencies. They have always been separate. If a case management agency also has a home health component to it, they're required to be duly licensed. So they have to hold two separate licenses. So case management agencies from a licensing perspective are not considered home health agencies. And so we suggest instead of putting it in section 2B to put it in the general section, which outlines all of the other entities that need to be licensed: hospitals, nursing homes, adult daycare centers, and all of those others. So it would just be its own section. So we took their language and amended that, put it, instead of keeping it in 2B, we're requesting to put it in section 2. And then we also removed a lot of the language that was not typically things that you would see in a licensing statute, such as the conflict-free case management. That's something that's a federal requirement. This is state licensing law. This is really about the licensure of case management agencies here in New Hampshire. And although there may be some requirements under the waiver and all of that, those are very separate and distinct and not actually part of any of our statutes when it comes to licensing. For example, hospitals are currently licensed. There's many federal requirements that hospitals are required to comply with, but we don't put all of those requirements in the licensing statute. The licensing statute is just there specifically to say the state needs to license these entities, and it's for the health and safety of the patients that are being seen or the clients that are being seen by those entities. And so that is our suggestion. So we are comfortable with the definition language that they have. We just remove some of the areas in which it may be something that's in a federal law or in a waiver or somewhere, and that is essentially typically something you would see in rules. And so that's what this amendment is for. I know there's a lot of things that have come up, a lot of questions. I'm happy to go through and answer some of those questions. I don't know if anyone if you want me to pause now and see, or if you want me to go through and answer some of those questions.
Representative Pearson?
Thank you for coming before us.
course.
Did you present what you just presented to us to the Senate?
So there was a presentation. I did not present it. There were other members who presented it, and I don't know if they got into this grade of detail. The amendment, the language that we had proposed, and the amended language that came the day of the Senate hearing, the public hearing. I wasn't physically present, but they were different, and so that was. I'm not 100% sure what the testimony was, but I don't think it was to this extent.
Wasn't that nice? They're letting us to weed out the details. Representative Saita.
Who's doing the licensing here?
The Bureau of Licensing and
excuse me, does the HHS have its own area of licensing?
Yes, sir.
Then why is this bill here? This is a headache.
Because it's in statute. A lot of the requirements for licenses are in statute. They can't just make up of the need for a license and impose it. And why is it here? It's because we're stuck with it. I will say that it is extremely unfortunate that this is showing up today because our deadline is next week. I would appreciate having copies of your amendment, and then I think we will let people ask questions.
Absolutely. You want me to hand that now?
Yeah, pass it around. And who are there questions, please? From anyone on the committee? Okay, well, I do kind of have a question.
Of course.
So you are, of course, working to revise your 819 rule,
Yes.
which is expiring in January, right? Okay. And you have no problem with continuing the licensure?
Correct.
There's just a disagreement from
On
you
the
of
placement.
where it should be placed. Okay,
Correct.
fine. And the issue with the conflict-free case management is not in the home and community-based care. It's in the other areas of Medicaid case management, DD, and so
Correct.
forth. Okay, well, that's helps me to understand. Does anyone else have any questions or clarifying while we have all these experts here? Representative Lekis.
So first, I understand you have this amendment. You've got some concerns about the current Senate bill, but I guess my question is, if the Senate bill were passed as it stands right now, first of all, do you think you'd have the authority to license these case management organizations, number one? And number two, what problems do you think would be caused with the current language?
So, as for the placement of it, the case management agencies are included in the home health statute. There's a lot of requirements under home health that don't exist for case management. Case management, as spoken by Alex earlier, there is home health care is a direct care service, and case management is indirect. And if they currently have to be duly licensed if they perform both services. And the oversight of a home health agency is very different in that we actually oversee the services that are being provided. We conduct surveys very differently at a home health provider, and we review medical records and other things differently than if it were a case management agency. And also the home health, I've spoken with Gina Bulkus here, and she's here from the Home Health Association. They haven't been considered, a case management agencies have not been considered a home health from their perspective, but the certification as well for Medicare, because it's the Bureau of Licensing and Certification. Many of our home health agencies are certified as well as licensed, and there's a what it's called is a deemed licensure. So if they're compliant with CMS regulations under certification, they can receive a state license. And so we typically have very different sections for each of those entities to be surveyed in very different ways because of the fact that some of them are certified, some of them are not. Some of them only provide personal care, some of them provide a whole host of hospice services. So it would make the department change a lot of its practices, and it may have unintended consequences that we're just not aware of yet.
Okay, thank you.
Other questions? Representative Bailey?
Thank you. Just a clarification. Earlier, we heard about at least some subset of this is conflict-free, which evidently means they don't actually provide any services at all. They arrange for other people to provide services. Is that correct?
So the conflict-free case management is something that's in federal law that's required and is being overseen by our long-term supports and services. That's not actually a licensing function, and that's one of the requests that we have is that be removed because it's not a state law licensing issue. It's a more of a federal government and compliance issue with our current waivers and other services that are provided there.
And follow up. At one point, you mentioned there was a conflict where they had to have dual licenses.
That's
But
if they.
At that point, they would not be conflict-free, right? They're providing the same service they're managing.
So I have individuals here who may be able to answer that question, but from a licensing perspective, that's not something that we look at all because that conflict-free case management issue is a federal and a funding and a waiver issue. Licensing really just looks at, are you doing the services? Are you doing it in a safe way and to promote the health of the individual? If you're doing case management, you get one license. If you're doing home health, you get one license. Or if you're doing both, then you need to get 2 licenses. You need to have a license for each. So that's where our authority ends and some of the other, Medicaid compliance and all of that picks up. And so that's not really a licensing function at all.
Well, so one more. Can't you just give them their own paragraph?
Yes. Yeah, that's what we're suggesting is that they get their own paragraph. That is actually our suggestion.
Thank you.
Yes.
Other comments, Representative Fellows?
What are community settings? Is that nursing homes? Is it anything else?
Community settings are not in nursing homes. They're out in the community, at people's homes and other settings that would not be in a facility. In a like a nursing home or an assisted living. So they're not in a actual
Yes, that's why we have a
healthcare facility.
Medicaid waiver to provide these services outside of the facility.
Right, home and community based.
Ms. St. Cyr, would it be fair to say that your statute is a mess?
Yes. Yeah. And we actually have done so much work on it to try to amend RSA 151 because it's so large. I mean, we have drafts and nobody's ever really wanted to take it up. And we actually proposed it right before COVID and somebody said, oh no, not yet. So I'm happy to engage with anyone who is interested in amending our statute. It would be wonderful. It would be very helpful.
That's the impression I'm getting.
Yes.
All right. Any other questions? What? Yes, thank you, Representative Blackus.
This is actually, I think, a request to the chair. What I'm wondering is if the home health care people or the case management people are still here. I wonder if
We
they
have
have
another person in support of the bill who is a case manager who is up next.
Okay, excellent. Thank you.
Okay, other questions? All right, and thank you for your
Thank you so much.
testimony. Carolyn Virtue, back again.
Madam Chair, if it's okay, I sit with her. I sent my pin card up.
Thank you, Madam Chair, members of the committee. I'm sorry that you got a little more than you bargained for here today. I just want to say a couple of things. The reason we are before you with this bill is due to the lack of there's no institutional memory within the department anymore. There has been a great deal of change, and I have held a license as a healthcare provider in the state of New Hampshire for over 40 years. Home care licenses, hospice licenses, case management licenses. I was around when we did the inception of the case management licensure, and it was absolutely done under the statute that the bill as it came over from the Senate seeks to amend. Any claim to the contrary is patently false. The other thing that I heard here from Attorney St. Cyr is that we are not surveyed by her staff, and that our medical records are not reviewed. I have to apply for a new license annually with the Bureau of Health Facilities, and surveyors from her department come out and go through the rules and regulations and conduct a survey at my facility, which is several hours long, and that includes the review of medical records. So it's facts like these that are sliding into omission is the problem that we seek to amend here today. Changing this statute from our RSA 151, colon 2-B has unintended consequences, not the least of which is that it removes protections that are offered to the patients we serve. Now, we've always abided by those protections. If you want to trust us not to, we're not the only ones. There are 7 providers. I'm going to treat people with respect and dignity regardless of what the law says. And I will point out that I worked on those statutes and the language that's in there, as Gina Balkus from the Home Care Association should be able to recall. She was sitting beside or in the same room a lot of this time. The other thing that I will very briefly speak to is the other 4 waivers and the plan of correction. The plan of CMS first came down and said, New Hampshire, you can't provide case management like this in 2016. People testified here today that, we have time and there are all these groups working on it. CMS is sick of this and we're out of time. And it ends in June of 2023. And I think we should be careful, although we are not attempting to address that problem with this legislation. I would ask that you be careful not to bar any possible solutions.
Thank you.
Thank you.
Are there any questions? Representative Black?
So the question is, and it's not clear to me from what you said, are you supporting what's in the Senate bill as it exists today? Would you support this amendment, 1635H, which was just passed out? I'm trying to figure out what we can do that will actually help deal with the problem, and it's not clear.
So I support Senate Bill 333 as it was amended by the Senate. The additional language that the department has a problem with on the bottom was added by the Senate. It is language that appears in federal law. The Senate chose not to include the citation. I'm not exactly certain why, but that language must be followed whether or not it's in this bill.
Madam Chair, for the record, my name is Robert Clegg. The language in paragraph 2 was put in by the Senate, and they left out the site because we know that most of the time the legislature doesn't like to say the federal law, because then to try to change it requires a whole new set of rules. So they added just the language. And as Carolyn said, it does say here that it has to be conflict-free. And the problem is right now they're under a plan of correction because there are agencies that are providing both the case management and the service. And so you send one person to that location and you get to charge for two people, even though it's the same person doing the same thing. So that's illegal. And I understand that if they can get rid of case managers, then CMS does say if there are no case managers in your state and you can't get a case manager, then the provider can be also the case manager. Understand that a case manager is the one that sits there and says, here's what we believe these people need for services. Those services are granted. It's up to the case manager at that point to determine on their visits whether or not they're getting the services that the state is being billed for. And over the years, as I've been involved, I can tell you that many times they aren't getting the services they're being billed for.
Mike, follow up? Yeah, I'm more addressing not section 2 of the bill, but section 1 of the bill and the question of whether there's that language which puts it in 151:2-B or the proposed amendment which just puts it in 151:2 section Roman I-1. That if I could get an answer just to that part.
Just to that part, the Senate was offered the same amendment. The Senate rejected it. It was a different lawyer in the Senate. It wasn't Melissa, but the Senate outright rejected it. Every senator said no. And I don't believe that if you changed it back that the Senate would accept it. In fact, the Senate has said they won't. This is the way they want it to be done. The arguments over there took weeks. They weren't just one hearing. It was weeks.
Quick follow-up, hopefully quick. I mean, do you at least have can you summarize very briefly what their concern was with the proposed language by the department?
Every time the department came in, they felt that the department wasn't doing what it should do, one, as a part of a correction. If you're doing something that's not legal and jeopardizes our ability to collect money from CMS, they want the correction to start here and be correct. Case managers need to be where they've been and to be licensed the same way. There are a lot of things that if you did the amendment that they're asking for, case managers would no longer be able to provide services to private clients. And so there's a number of issues with that amendment that's been hashed out in the Senate, as I said, weeks.
Yes, thank you, and they gave us 3 days.
I agree.
All right. Any other comments, Representative Fellow?
I'm not entirely sure I even understand this correctly, but I'm wondering if the little amendment that we had is essentially the same words that's in the Senate bill. If when we get down to case management, we just use the first sentence and the last sentence and not the stuff in the middle about individuals' free choice.
I don't think that's exactly suitable for a public hearing at this point. It's
What?
You're wordsmithing, and that's more suitable for an executive session.
I'm just trying to understand if that set of words works for them, and it's just the.
I think they've already said that the Senate
They don't like the
fought
Senate.
over this for weeks and
Right.
refused it. So
So
I would say that means those words are not acceptable.
Okay, and then in that case, what if
Follow
we?
up?
Yes, please, thank you. It's late, I'm sorry. If we were not to pass this bill, the House were not to pass this bill, what would happen, and would the issues related to the federal money be addressed somehow?
If the House were not to pass this bill, we believe things would remain the same as they are. we would still be licensed under the home care, and we would still be case managers, and the state of New Hampshire would still have to comply with the federal law that says it has to be conflict-free.
Yes. And we have had testimony that the conflicts are primarily in the case managers licensed under RSA 171, which is, and I don't know if that is true or if there's some overlap. Or if that's even relevant.
I believe that they're unlicensed in the other systems, is my
Lovely,
understanding.
Lovely, thank you.
Yeah.
Any other questions for Ms. Virtue and Mr. Clegg? Okay, thank you very much for the information. Gina
Thank you very much for the opportunity to appear here today. I sat on this committee under Chairman Bob Mercer, and I learned so much from him and my experience. And if you still have the brick wall award plaques on your wall, do you?
It's still
You
there.
will find my name there.
Thank you.
Thank
Ms.
you.
Ms. Virtue. Gina Balkus.
Thank you, Madam Chairman and members of the committee. I'm Gina Balkus, and I'm the CEO of the Granite State Home Health and Hospice Association. We represent home care, hospice, and palliative care providers and the people they serve. So like Mr. Katrubis, when this bill was introduced in the Senate, we were neutral on the bill because at the time, the bill only had Section 1, which was simply adding case management providers to the home health statute. And I would agree that the fact that they arrange services qualifies them to be in that statute. I think that our concern, and the reason that I'm here today, is when I saw the bill as passed by the Senate with the new definition, I do believe the definition is overly broad and very confusing, and feel that much of the language that's in there about conflict-free case management applies only to federal waiver services. You may, in fact, have case management service provider agencies out there that are private only and that do not do any waiver services. So the definition should be much clearer. I feel that the department's amendment that was presented today achieves that. I do believe that I saw the amendment that was presented to the Senate. It was different than what was presented today because it included a list of service providers who are exempted. I think the amendment you have before you today is cleaner. And it just clarifies that case management agencies would have their own paragraph and own definition. I think that I have read the Home Health Client Bill of Rights. I think that could easily still apply to case management agencies. It could be applied in rule, or the statute could simply be amended to add that case management agencies should provide the Home Care Clients Bill of Rights. But there are other sections of the law that apply, including home care discharge regulations and other things like that. So I just want to, I was hoping not to have to jump into this bill because it seems now that it's gotten a little controversial. But I do feel the definition that was added by the Senate is very confusing and will muddy the waters for a range of healthcare providers that may in fact provide case management services under their existing licenses. And now we'll look at this and say, oh, do I now need to be licensed separately because we provide some of these services? So I would ask that you give serious consideration to the department's amendment that they shared today. Thank you.
Thank you. Are there questions? Representative Pierce.
Thank you, Madam Chair. Did we not just hear that under Part 2, basically line 15 on this definition is a federal definition? Did we not hear that?
So my understanding of the definition is that the definition is a federal definition that applies only to Medicaid waiver services, not services that might be provided by other case management agencies that don't have anything to do with waiver services. So it would certainly be appropriate to have those definitions in the waiver rules or the Medicaid rules. I don't think it should be in the statutory definition.
Thank you. Are there any other questions? All right, I know. Thank you very much for your testimony.
Thank you.
Is there anyone else who wishes to testify on Senate Bill 333? All right, seeing none, I'm going to close the hearing. We will not be voting on any of these bills today. And I would hope that all members of the committee spend their weekend reading RSA 151 and studying up on it. There will be a quiz. Representative Sytek.
I'd like to note that we're adjourning at 4:20.
Thank you. We will celebrate appropriately.